ಸರ್ ಕೋಟ್ ಹಾಲ್ 11 ಸರ್ ಕೇಳಿಸಿದ್ಯಾ?
ಮ್ಯಾಟರ್ ಗೊತ್ತಾಗತ್ತಿಲ್ಲ ಏನಾಗತ್ತೆ.
ಹಲೋ ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ. ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
Can give memos, just one niche. Other memos you can give. It will come up according to date wise. Give other memos. Only tomorrow you make a mention. Just wait. Other memos you give. Others need not wait. You can give the memos and go. Only those you want for tomorrow you must make a mention. Yes. Check mud. 9th. Yes. Monday orders list. What will happen? Monday orders list. Friday we have other matters. So it may not reach even if you list it tomorrow. Monday in the orders list. Yes. Have it tomorrow, but you serve the other side in advance. Let them come. In their presence, we can do something. I'm not inclined to pass ex parte orders, but in their presence, we'll see if something can be done. Yes. Monday. Tomorrow it won't reach. Yes. Could fresh matters will come out. Fresh matter will come. The auto listing, fresh. Badly. You appear for tomorrow. Monday.
And these are three different points of findings that come up with the score or they were all three directions were issued by this court regarding the disposal of this suit at earlier. When the cross-examination was in the again one more application was filed and rejection of the plaintiff, amendment to the plaintiff was rejected. And now the matter is stayed with this court.
Tuesday.
Three directions of this court.
Tuesday.
It be on the piece of
Tuesday.
Monday, I just
Monday it may not reach because the list will be long. 2:30 I have election matters. So you'll have it on Tuesday. You take a What will happen? After all, property has to be divided. Next week. Nothing will happen. Yes. Check. What have you challenged? No, what have you challenged in your writ petition? Monday or Tuesday? Tomorrow. Yes. You serve the other side. Serve the other side in advance. No. Unless you challenge that ex parte decree, what relief you can give? What happened to that? You have challenged. What have you challenged? Monday. Yes. Where's the other side? Inform the other side. Correct. Inform the other side. Inform the other side and just get his signature on the memo and give it to the court office. Otherwise, when it reaches, I will accommodate. Otherwise, in advance, you just ask him to sign a memo for adjournment and give it to the court office.
ಅದು ಸುಳ್ಳು ಪದ್ಮಣ್ಣ ಅವ್ರದ್ದು ಬಿ ಗ್ರೂಪ್
Intimate the other side and tell the court office. Yes. ಚೆಕ್ ಮಾಡ್ಬಿಡಿ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ I will pass over. If it is, I'll ask the court officer also to check. If it is so, we will only pass an order. Otherwise, I'll adjourn it. $35. You appear for? Who's the other side? Inform the other side and report to the court office. 37. Learned counsel for the petitioner has filed a memo which reads as hereunder. In light of the same, the petition is dismissed as the relief sought for do not survive for consideration. Yes.
40 to 46.
My lord, serial number 41, my lord.
Yes.
My lord,
Yes.
the office has raised the objection with regard to maintainability, my lord. That is correct, my lord. What I have challenged is the decree, compromise decree. I was under the impression that, my lord, it was settled before the Lok Adalat. It was not so. Therefore, my lord, the office has raised the objection. With
So you withdraw it, reserving liberty to challenge the impugned order in appropriate proceedings.
yes, my lord. I'll file
Memo filed by counsel for the petitioner
Please, I'll file my.
seeking liberty to withdraw the petition in light of the objection raised regarding maintainability, while reserving liberty to challenge the impugned order in appropriate proceedings. Accordingly, petition is dismissed. Original certified copies, if any, to be returned to the petition. All conditions are kept open. Yes.
Number 6, 47 to 49. 7, 55. 8, 56, 9.
Yes. This is the matter. Week after next. Yes.
Number 9, 17.
This is the matter next week. At request made on behalf of the petitioner. Interim order earlier granted is extended till the next day. What is the status of the case? Order is of 2019. No. Is the matter next week? Yes. No representation on behalf of the petitioner. Is the matter next week? Yes.
Number 3.
21.
And then progress.
Okay, you take out notice. To notice to the respondent, same order.
And it's more submitted to.
Yes, yes. That is the order that I passed. Yes. So that's a different matter. You serve it and move the matter. Let us. At request of counsel for the petitioner, list the matter week after next. Yes.
Number 5. It's my MS.
My lord, I appear for the petitioner. My lord, the petitioner has filed an impleading application to implead in OS number, my lord, 97 of 2014. That
No, you take out notice. Take
Please.
out notice.
is
You should notice same order. Let's check pass over. Check my case status.
PM.
Take out notice. You should notice same order. Yes.
8. That is your.
Office objections to be complied with. List the matter next week. Yes.
9. Action.
Office objections. Nobody one inch. No, but office objection at least when the matter is coming up. On the matter. Yes, yes. No. Now, what is the order that you have challenged? To lead evidence. So you serve the site, we'll hear them out.
All the parties are not making parties, they are all partner parties. Both parties, there are two objectives, there are two. They had already appeared in the connected matter and it is permitted to take notice of them, the local public here, for 2 reasons.
No, that I'll permit you. So which is that connected matter?
The connected matter has been disposed of against this order, which is found at my lord page 30, earlier number 2. Against which there are MBK has been filed by them. That MBK case will be allowed. Only that.
No. Only asking you. You're saying that you want to take out notice as counsel appeared in some connected matter. Which is that connected matter?
That okay. In inspection number 9267/22, that inspection has been disposed of.
So that will be in addition to notice. Let us give you liberty to serve them.
Only to specify the size that we take that.
I'll permit you. Yes, you appear for undertaker. Which respondent?
Respondent number 17 and 18. Page number 2. Alternative memo. Page number.
The learned counsel, AGA, undertakes to appear for respondent 27, 28, 29. Copies to be served forthwith. The petitioners at liberty to serve the counsel. Now in the trial court, nobody appears for these respondents. Petitioners at liberty to serve the counsel appearing for the other respondents before the trial court, as well as serve the counsel who stated to have appeared for these parties in WP 9267 of 2022. This would be in addition to emergent notice through court. Yes. Completing application for as in the capacity of
After the I think respond number 2 to the respond number 3. Respond number 1 to the small part. In that school, I sought to increase access to protect my interest. Now, when
what is correct? Let us see. It, technically, these are independent proceedings, though the sale deed passed cannot confer right more than what they have. So, what is the legal position you point out? You take out notice, and then next date you will see what. No, nothing else. What will happen? That we'll take care of. You first serve the other side and move the matter. In their presence, we'll see, and then you point out what is the legal position. Insofar as co-sharers seeking to implead in suits for specific performance, what is the legal position you place? So you take out notice. Yes. Yes. Issue notice, same order. Even the format ordered. I permit all the three. No, you move the matter after you serve. Counsel for the petitioner files a memo and submits that the reliefs do not survive for consideration and matter has been rendered infructuous. In light of the same, petition is dismissed. Contentions are kept to. Yes. You take out notice. Now you accept notice, government. Acquisition proceeding, execution is pending, but nevertheless you find out why, what is the difficulty. Now they'll have to pay more interest. To find out what is there any other difficulty or only a resource crunch. That AG accepts notice for the respondents. List the matter. After 2 weeks, I'll give a date. By then, get instruction. Date 19. You take out notice. What to do? 70 IAs you have filed. No, that we'll see. You serve and immediately move the matter. Page? So note to issue notice to Respondent 6, 7, 8, 20, 22, and 23. And 22 and 23. Same order. You can serve the lower court counsel also and take it and then move the matter. ಯಾವ್ದೆಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು ಅದರಲ್ಲಿ ಒಂದು ಬರೆದು ಬಿಡಿ ನೋಟಿಸ್ ಆಫ್ಟರ್ ಅಥವಾ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಯಾವ್ದಲ್ಲಿ ಇರುತ್ತೆ ಅಬ್ಜೆಕ್ಷನ್. ಎಸ್
Again, you can continue.
ಟೇಕ್ ಔಟ್ ನೋಟಿಸ್. So now, correct. No, correct. Now, you take out notice in their presence, we'll see what is. Next week itself, you move the matter. Let me hear and then pass. The court has said we are trying to obstruct whatever it is in their. No, let's see what I'm saying. I'll hear the other side. You immediately move the matter next week. Take out notice. Issue notice. Same order. Yes, and then move the matter. You move the matter. You move the matter. I'll give you a date. Once you serve, you move the matter. You can also take out notice by way of hand summons. You move the matter. I'll give you a date.
14 Nagaraja.
Mike, ಸ್ವಲ್ಪ mic adjust. Now both are concurrent findings, isn't it? So you take out notice, let them come, we'll hear the matter. Issue notice to the respondent, same order.
15 is an B.
Notice 14. There's a curator who's there on record. Office the curator to file statement of objection to the petition. List the matter in detail. Correct. Concurrent finding. You take out notice. No ex parte order. MA. Hello, one nimsha. You have the file. Do you have the file? Isn't it concurrent finding? Correct. Now, anyhow, we will hear it, but no ex parte order in this. You take out notice and then move. Pass. You take out. When is the next date? Which year? 2010 soon. You're not going to stay. You serve and then you move the matter. Serve it. Serve it. Serve it. Serve it and then you move the matter. 2010 soon. Correct. That agreement is of which year? And the suit. No, correct. The suit is of which year? You're seeking not binding. Then look, that's why the court says.
Yes, we have done amendment was taken and was implemented. The other advocate and then my mother was.
What happened to RFA?
Please.
What happened to the RFA?
I should not. Explaining.
Then
So this. Please, again, we are the.
so finally you are not a party in that.
That's to that.
So
Only I am asking amendment in this year. I think I will party in this. I am asking only amendment in this year.
correct. Now since you are not a party in that suit, obviously it's not
That
binding.
is different, because I issue. That's it, we have to amend, including the.
Take out notice. Take out notice and move the matter.
Because
Let it be decided only. The appeal you take up this. I won't allow this. After how many years you file? After 12 years, the suit is of 2010. This issue notice. Take out. Let it. Yes. Tuesday. Yes.
17.
You take out notice. We'll hear and then we'll decide. Let us see. You take out notice. Let the other side come with you. No, let us see what it is. Let the other side also come. We'll have it next week. We move the matter after serving. We will, in presence of both, we'll pass some order. Notice. No. Let us issue notice. Same order. You also can take out by hand summons also. And then after the serving, you move the matter. We'll see what is.
Serial number 18, I appear for the petitioner, my lord.
No.
Serial number 18, my lord.
Yes.
I appear for the petitioner, my lord.
Let us see. Let it come. We'll hear it.
Cavator is there, my lord.
Correct, but not in fresh matters. Let it come in.
My lord, the suit is posted on Saturday. The court is insisting that to file a additional written statement. In this petition, my lord, earlier the petitioner, the respondent had filed an amendment application which was allowed. Subsequently, after 6 years, when the at the stage of final arguments, he comes out with an application again for amendment. The amendment runs from page 71 to 78. 8 pages amendment. The court has allowed only on the ground that relying on the Supreme Court decision that due diligence was there. My lord, kindly turn to page 78, my lord.
We'll have to hear the matter. Now I can't dispose it of fresh matters.
Very well, my lord.
I'm not going to stay the proceedings.
My lord,
I'm not going to stay the proceeding. We'll have it next week. We'll hear.
Saturday it is there, at least till the next date, my lord.
No stay of suit is of 2017. You rather file written statement and finish rather than the matter being
here. Twice written statement was filed. Additional written statement. This is again they have filed the amendment application. Entire proceedings, entire evidence after completion, after admission from the respondent. Now they have come up with this fresh pleadings of 7 pages, my lord, from 71 to 78. Entire. Then once then again additional issues has to be framed. Fresh evidence has to be led in, my lord. Till the next date, my lord, I am not seeking. Let the matter can be heard. I am ready, my lord. But till then, because the court below is insisting to go file the written statement, my lord. And the first amendment was allowed in 2016, and he says that only recently I came to know about the exact measurement. That is after 6 years. Who is my neighbor? The respondent is my neighbor. He says I came to know only recently. After 6 years of second amendment, he files this fresh application. The amendment itself runs to 8 pages, my lord. Entire pleadings are changed. Evidence is completed. Cross-examination he is admitted. After everything, now they come out with this application, my lord. After 6 years, after the first amendment, at the stage of final arguments, the suit it could have been disposed of. He's trying to cover up his lacuna in what the cross-examination, what he had admitted. And entire fresh pleadings itself, madam, the pleadings itself runs 8 pages. And the trial court is insisting that immediately written statement, it was posted day before yesterday, from that it is posted to Saturday, my lord. I am ready for hearing on the main matter. Till then, the matter can be stayed. I am not protracting all. In fact, he has taken 8 years to lead in his evidence. It's his suit, my lord. Respondent suit.
Use the mic. Use the mic. Just see the mic is on. Yes.
Responding number 1. If I may quickly come up with facts, cognitive injunction and mandatory injunction. Responding number 2 and 3 and the present petition. So, on the date of filing this, the comments commenced. They are not looked up entire construction. And during the pendency of this was when they kept constructing the building. And nowhere in their written statement nor in their additional written statement they have mentioned that the construction is over. Even the additional written statement, they have mentioned that the at stage of pendency. They have not mentioned that it's completed. And moreover, there's a clear admission by the present petitioner where he says that all the events have taken place in pendency. He accepts the fact that he's subsequent events. That is my first ground, Your Honor. And if I may move to the objections that is filed by the present petitioner, the IA number 8 of 2022. So both the grounds.
No, you go to the reasoning of the trial court.
Please, Your Honor. So the present petitioner has stated.
Read the reasoning. No, but how we can dispose it of at this stage? And suit of 2014, if we are going to stay, then how court cases will progress? Yes, you read the reasoning, let us. Otherwise, I'll pass over and take it up, let us. I'll pass over and take it.
Very well.
No representation on behalf of the petitioner.
But I am for, but serial number 19, my lord, I am for the petitioner.
Yes.
The suit, my lord, is filed seeking for declaration, which has been dismissed, my lord, on the ground that, my lord, the memo has been filed by the council that the party has, my lord, settled out of court. But based upon that memo, my lord, the suit has been dismissed. Thereafter, my lord, the petitioner's signature has not been taken. The council has filed the memo. Thereafter, my lord, after gained the knowledge that, my lord, the advocate who is filed the memo has already died. Then, my lord, the mispetition has been filed. Now, my lord, the mispetition has been dismissed on the ground that, my lord, there is a delay in approaching the court. My lord, the respondent has not appeared in a mispetition, my lord. Even before the suit, also, my lord, the only, my lord, 3 defendants has been appeared, and the other, my lord, the respondent has not appeared before the trial court itself.
No, you take out notice.
Please, ma.
This is not an appealable order, is it?
But no, my lord.
Okay,
Against Miss, my lord, the order, my lord, the writ petition GMCPC is maintained. Since IA for condition of delay has been dismissed.
But that amounts to a confirmation of the order on merits. The dismissal of IA
Please,
will amount to confirmation of the order on merits. You may have to challenge that.
But liberty may be given, my lord.
You just check. I'll have it next week. You check
Please, please,
check legal position and make submission.
please. Next week.
If the application for limitation
Please, not. I don't.
is rejected, you just check the legal position. You have to challenge the main order.
But the main order has been challenged in this writ petition also.
The office objection. Just a minute. We have complied with all the office objections.
All the office objection has been complied, my lord. Now the matter has been posted for preliminary hearing.
You just check. I'll have it once. There is some doubt. What is the remedy available as against?
Please.
We'll discuss next.
Next week.
The matter next week.
My lord, date may be fixing.
Date could be.
Serial number 20.
No representation.
Appear for the petitioner, my lord.
Yes.
So your lordship may kindly have it next week, my lord, because tomorrow case, client has taken the copy.
This is the matter next week at request of counsel to the people.
Highly obliged, my lord. Highly obliged.
Serial number 21.
No representation on behalf of the petitioner. This is the matter week after next.
22.
Without copy.
Yes. One number. That. Here is.
No, let them come. We'll have it. We'll hear them. Let them come. We'll have it next week. Let us see. Let the other side come. We'll hear what is on what ground they were impeached. No representation on behalf of the curator. It's the matter week after next. Yes. The others notice to the 3 to 10. The others notice may be waived because these are the only contesting, or you take out notice to the others. You should notice to respondents 1 and 2, same order. Yes.
To issue a certificate of petitioner law. Respondent 1 to 4, the fraud party is open fraud against the petitioner without making the party. Then when a payment is being done, that petitioner not party. Then immediately went to the other court. When an application for last years, last applying copy my lord. The international legislation is not of the good level because they are playing for last 2 years, not giving the public law. Case number 1516.
We'll have it day after tomorrow. I'll find out from the on the administration. We'll list the matter day after.
24, Mr. Chairman. Thank you.
Yeah, he made a mention for time at the request of the petitioner. This is the matter.
After the originals.
Let us see on the next date. At request of the petitioner, this is the matter week after next.
The repetition of
order going to
So the arbitration proceedings have started.
it is only the arbitration by the space where despite one person even suit is not to restrain the engagement of a breach of the contract. Very other than not what's happened. Legal between overnight other than the rate of business. I intend to Naveen, staff, I recruited staff, I engaged people, no, I ran this business. So COVID, I ran business. What happened is, they entered into an agreement with Big Basket. Wanted to Big Basket comes on the directors of Big Basket come on board on this company. And on the website, they simply transfer all every single person who registered here. This is transferred onto their website. Business is not taken. They are not parties to the arbitration. All the court below does this. They will not be parties to the arbitration. And Section 8 petition is allowed. On the ground,
But the non-party is also that legal position.
let me put Europe the concept of group company. What circumstances are non-party to form? It's not all of that. It's none of that. It's not in anyone's case that they are bound by the they are not bound by it. I'm also not saying that they are bound.
Yes, file your synopsis, we'll take it up. Both sides, to file their synopsis.
Already ordered past that mapping is 28.
List of dates, summary of legal contention, and authorities relied upon. This is the matter on. After serving, advance copy on the side. Week after next one, date 19th is an election petition. So until that is concluded, there will be some difficulty. But let us, on every day, I'm taking it till I conclude it. So let us see. We have 19th, and let us see. But on every day till the election petition is concluded, I'm taking it up. Someday there'll be breaks. We'll see. We'll have it on 19th.
Court has passed the order that we don't have to pay that. And it has been insisting on principle. Election even earlier.
Read.
Many of the provided by the Vishas in Nalo, one. The prayer for appointment of receiver is rejected, but an alternate leave for interim maintenance is allowed. Each appointment of 1 and 6 shall pay monthly maintenance of the bishop on the honor of preceding month from the date. In 2012, until passing the order in the AP law, have paid the entire. Now they want they are seeking the once again that what has page number 44.
Yes.
Page number 44. Last paragraph.
Yes.
In this case, what is to be seen on which back of the monthly maintenance of the master. So everything that point number one, they can come up. The commissioners are entitled for 948 share as degree and others. Before that the workout is very. However, shares are also.
No, the court says that this amount will have to be paid till possession, delivery of possession of share allotted to the petitioner. That's all it says. So you have to continue to pay. Delivery of possession. So this 3,000 that was earlier ordered to be paid on
24%. But till 2011, what has paid entire.
correct. So from then you'll have to pay. Because you are in occupation, that's what it is. Because you are in
Question whatever.
No, that after taking note of payments made pursuant to the order of IA 4 and 7, balance you'll have to. You can only clarify that much. That you have made some payments after IA 4 and 7. Balance you'll have to. That's all, isn't it? The petitioner is sought for setting aside of the order of 7/4/22 passed in execution 4 of 2017 by the court of the senior civil judge in JMFC, whereby application filed under 151 of CPC by judgment letter number 2 was rejected on payment of costs. The counsel for the petitioner submits that in terms of the order, in terms of the earlier order on IA number 4 and 7, the petitioner has been making payments at the rate of rupees 3,000. And has made payments in terms of the order till 9/11/2012. That is till the date of disposal of FDP. However, it must be noted that the court, while dealing with IA number 3, is that was of the view that the said amount is required to be paid till delivery of possession of share allotted to the petitioners. The stand by the trial court is equitable and does not call for interference, as the petitioners admittedly had continued in enjoyment of physical possession till 20th April 21, on which date possession was handed over. Accordingly, we find no reasons to interfere with the order while clarifying that the previous amounts paid ought to be taken note of while quantifying the liability. Accordingly, petition is disposed of. Now you appear for the plaintiff or the defendant. What did you want to produce? You have not, now it is at what stage? ಅದು ಕೊನೆಯಲ್ಲಿ ಹೇಳ್ಬೇಕು ನೀವು judge whether he's made up his mind after you make out your full case at the end. No, correct, but you must leave it to the judge, but then you must make out your case. Now why you could not produce that electronic evidence earlier? Airtel has given a certificate that the material is not available. Now you just read the reasoning from para 6 onwards. Para 6 onwards at page 91. Yes. From para 7 onwards you read.
Also for the different don't be recorded in the
Continue. You take out notice and move the matter immediately. IA number 31 and 32. And court has held, Airtel says they don't have it. Who has recorded it? What is the evidentiary value of that? You have not mentioned this regarding the existence of this in your written statement. Page? Page?
Page
20?
28. Hello, further subject, right? There is a notice received from them. And it is a format 80. Nine comes for the 148. Nine.
In which CD? Where have you recorded? How are you going to now get material from the memory card unless it is recorded as a voice message? Not at this stage, not after this 10 years, 9 years. You produce it. You have a extra copy of the CD, you produce it. Let us see if it will give this information. Let us have it next week. Immediately you serve it and you move the matter. Let the other side also. You should notice same order. Petitioner is at liberty to move the matter after service. Yes. You move the matter. As soon as you serve it, I will fix a date. No representation on behalf of the petitioner. What is this matter?
During the arrival. Already Tahsildar is executed. For the whole period.
Is the matter after 2 weeks? He was there, no? Also,
30. And then okay. Number 30.
but there are division bench judgments also contrary. Contrary to this. Sarah? Now, what has happened in your suit?
No.
Page. Next year? Page 58. This is not the suit agreement. No, this is not the suit document. The counsel for the petition submits that the exhibit P15, exhibit P14 was marked and admitted in evidence on 26/3, and that memo was filed. Memo was filed by the defendants raising objection regarding insufficiency of stamp duty on 4/9/2021. And accordingly, once a document has been marked, the question of insufficiency of stamp duty paid cannot be raised at a subsequent stage. Subject in light of the contention raised in further consideration, there would be stay of the impugned order dated 12/8/2022. Clarified that the suit proceedings have to go on. Issue notice, same note.
There is no counterclaim. Third, judgment. You also not third, application not election money. D, is right not seeking I not application not. Nine properties only. You are not ends of justice.
What was the stage when you filed this application?
Right, it was an argument stage. Now it is a stage of argument.
No, correct. It was at the stage of arguments when you filed your impleading amendment. No, correct. But then how you can't file cross counterclaim after the stage of. Even after there is a judgment, isn't it? The apex court. It says counterclaim you can't. No, the judge. No, correct. In terms of the judgment of the apex court, only the judgment of Justice Mohan Shantan Gowda says still the framing of issues. No, but you look at the judgment, realistic, you get the judgment. You know that the three judges here in the judgment, limitation for counterclaim. Let us have a look at it. When do you want? Put it. Give a copy to the court officer in tomorrow. ಅಲ್ಲ ಸಾಯಂಕಾಲ ಕೊಟ್ಟರೆ ರಾತ್ರಿ ಓದ್ಬೋದು. So what is the fine? So that circular we have referred to.
Page 500.
You take out note. He is. Seventh time.
Single bench calculus. No, no. Not single bench.
The third time into the seventh time into might be.
Dividend benches has come up. Dividend benches have.
In light of the order dated 21/7/2022, it was stipulated that if office objections are not complied with by the next date of hearing, petition will have to be dismissed for non-prosecution. None appears when the matter is called out. It is made clear that if office objections are not complied with by the next date, necessary orders will be passed. Deal is the matter finally on.
34. Randeep.
The orders.
Appearing for the petitioner, my lord.
Yes.
34 appearing for the petitioner, my lord.
Yes. Yes.
Pursuant to your lordship's order appointing an arbitrator, my lords, an application under 17 was filed before the arbitral tribunal seeking for furnishing of security against the respondents, my lord. An order came to be passed on 17/12/21 by the learned arbitrator directing the respondents to furnish bank guarantee for securing the amount in dispute till the adjudication of the dispute, my lords, which was not complied with. Therefore, an application was filed, my lords, for initiating contempt under 27 read with 17(2). My lords, that order was passed on 21st November 2022. If your lordships have that order, my lords, I think along with the letter of the arbitration center, my lords, the director has furnished that, my lords. Last page, my lords, page 14 of that order.
Yes.
In view of the above discussion, I am of the opinion that respondents have not complied with the order of this tribunal.
Page.
My lords, page 14, page 14, my lords, along with the letter of the arbitration center, my lords.
Paragraph
20, my lords.
This is the order on IA number 3.
Yes, my lords.
Para 20.
Yes, my lords.
It is true that. Read.
Yeah, in view of the above discussion, I am of the opinion the respondents have not complied the order of this tribunal, and therefore under section 27(5) of the Act, the representation is to be made to the High Court for taking necessary action under the Contempt of Court Act 1973 for non-compliance of the order.
Just which paragraph?
Para 20, my lords, page 14. This is order on IA number 3 in AC 173 of 21.
Yes.
Page 14, my lords, internal page 14.
Yes.
In view of the above discussion, para 20, in view of the above discussion, I am of the opinion the respondents have not complied with the order of this tribunal, and therefore under section 27(5) of the Act, the representation is to be made to the Honorable High Court for taking necessary action in the Contempt of Court Act for non-compliance with the order dated 17/12/21 passed by this tribunal, accordingly ordered. This order is submitted to the Honorable High Court along with the order under section 17.
Very aromatic. It was passed, which was not complied with.
Yes, madam. The first order, my lords, is of 17th of December 21. That is at, my lords, along, that's on IA number 1, page 25 is the, page 15 is the operative portion, my lords, of the arbitral tribunal's order.
So now what is the procedure to be followed?
My lord, they have to comply with this order, my lord. Your lordship will have to direct them to comply with this order. Under 27(5), my lord, the assistance of the court is sought for of the Arbitration Act.
Arbitration and Conciliation Act.
Yes, my lord. 27(5), my lord. Section 27. It starts with the heading Court Assistance in Taking Evidence. Section 27. Starts with court assistance in taking evidence. If you watch it, kindly see subclause 5.
Yes.
27. Persons failing to attendance in accordance with such process or making any other default or refusing to give their evidence or guilty of any contempt to the arbitral tribunal during the conduct of arbitral proceedings shall be subject to the like advantages, penalties, and punishments by the order of the court on the representation of the arbitral tribunal as would incur for the like offences in suits tried before the court.
So what is your stand?
Sorry, my lord?
I'm asking the respondent. Adjust the mic.
Yes. My lords, Khaitan and Co were not the counsels who were representing the respondents. My lords, if your lordship kindly see the order S. Samartha. He was the advocate representing the respondents. I think probably his name should be shown, my lords.
So who appears?
Yes,
Whose name
Samartha, my lords, advocate. Lordship may kindly see the order of 21st November. After the cost title, my lords, your lordship should see at the end after respondent number 15.
Yes, Samartha.
Yes, yes, my lords. Probably his name should be shown, my lords, instead of Khaitan and Co.
Lord, counsel for the petitioner is permitted to serve appropriate copies on.
Copies will not be required, my lords, because they were representing in the arbitral proceedings itself. They are aware of this order.
Copies to show the name
In the
of.
CM, my lords, they were not.
Copies to show the name of Lord Counsel S. Samartha as representing the respondent.
Yes, my lord.
Before the arbitral tribunal in so and so.
In AC number 173 of 21.
In AC number 173 of 2021.
Yes.
Relist the matter next week on date.
Next week, next Thursday, my lords, 12th, my lords.
Yes, 12th. Office to delete name of Nikhilesh for Khaitan and Co for respondent as shown in the cause list.
Date for my lords.
Please, my lord, I appear for the petitioner, my lord. Kindly 2 days may be granted, my lord. Sorry, my lord, I was not able to amend the cost title, my lord. 2 days accommodation, my lord.
This is the matter next week. At request made on
Date may be given because suit is of the year 2014, my lord. My learned friend is also appearing on VC, my lord. Let it be taken up on 12th or 13th, my lord. Only short point is involved, my lord.
Let us see. We'll list the matter on 12th. Yes.
Please, my lord. Obliged, man.
36. 36.
The other office objections you comply with. 36. 37 until June. 53189. You comply with the office objection. This time granted for compliance of office.
8 files are 38.
Yes. No, no. So office objection, have you given your explanation? So in the cost title itself, you have mentioned. Page. It is submitted that where is the plaint is that page? Annexure L. She's the first defendant. Is it? Her LRs were not brought on record. In light of the submission of counsel for the petitioner, the office objection at field number 2 is kept in abeyance for the present. We'll see later. Then the other one you have complied. You have mentioned the IA details that you have mentioned. Second office objection. That you have clarified. Yes, what is the matter? When was that? Yes.
Then I issued the notice, 11/3/2021. It should be restored. Prior to that, I have not received any notice, application filed by the client. I only received the notice on 2021, after 3 years. It should be restored. And subsequently, I filed in 2021. I filed the application for permit me to file it. So the report says that even if the variance is out of the scope, the period is counted, saying that I approve the after lapse of 3 years. 3 years time equal to dismissal. I was not able to file it. Because they are not ventured to file any application. The only issue is.
Now, what is the No, what is the stage now?
Stage is for cross-examination. I filed the application to cross-examine.
Right, okay. Contention raised that the suit came to be dismissed on 11/10/2018, and subsequently notice was received in March 2021. The court ought not to have taken such time into consideration while rejecting the application seeking permission to file written statement and reopen the case. Subject to further consideration, there will be a stay of further proceedings before the trial court till the next date. Same order. You serve and then move the matter immediately. There's no point in keeping it. Interim order would be enforced in the next date. This is the matter after 2 weeks. That is on the main. That is on the main. No, we'll have it next week. Let them serve on the council appearing in the trial court. If they don't come, then we will decide. Be submitted by council appearing for R1 that except the first respondent, none had filed objections to the amendment application, and that the survey court need not wait for the service to be completed as regards R2. However, as another final opportunity, counsel for the petitioner is permitted to serve counsel who appears in the trial court for R2. Relist the matter on next Wednesday. Interim order earlier granted is extended till the next date. Yes. Yes.
Was not compassed.
Yes.
There was interference by the petitioners. Police protection has been given, not 24 hours, till 7. Defendants interfere. The immediate prayer and holy man is granted, not arrest. But the 9 months, the police also to come in here. And then I am immediately
Land counsel to the respondent submits you to file.
I have already filed an affidavit counter in case of the need arrests joining.
Seeks for time to file rejoinder if any. Relist the matter next week. Now, as on date, there is some interim order. This is the matter week after next. Yes. What? But defendant number 4's legal representatives. Where office of teaching complied. Others you have complied now. You will comply. What is the matter?
The two files the opponent, prospective opponent, against the mother, the third opponent, the mother, second respondent is the fourth respondent is first cousin. What is actually petitioner beneficiary under the grandfather, 1998. Get a page 45.
Now, what is the impugned order now?
Impugned order, 14. Saying that the petitioner is the third party and this application the property. The mother and the council have no right to. They have only right to pay the image. Alienation, mortgage, all these what the grants are looking at. The petitioner being the grantor, along with the fourth respondent, they have every right. And the government has equal. Now, the impure order is not a state order. There is a third party, you cannot.
Now you serve it and you move the matter. We'll have it next week. You serve it on the trial court advocate and move the matter. Let us. Let us see. Let it come to that stage. We will hear the other side and see what is to be done. You notice the petitioner is permitted to serve counsel appearing for the respondents before the trial court. Petitioner is also at liberty to take a hand summons be served on the respondent or his counsel who appears in the trial court on the next date of hearing. the presiding officer to facilitate the service of summons. You serve and immediately move it. I'll give you a date. And then what is the legal position insofar as third parties' interests or regarding the suits or specific performance, legal position also you get. Office objections to be complied with forthwith. Yes.
Yeah. Wait on this. Additional report notice, I also issued. Having served on the 28th. At yesterday, presented on the respondent of.
No, some interim order is already passed. Interim order earlier granted is extended to the next date. Petitioner is permitted to comply with the office objections. Matter is adjourned. Let us see. Let him appear and then. Yes. You comply with. I've ordered. Which is that? Which?
He said my synopsis is not
No, so that one by one is. So now, synopsis to be in chronological order. Check it out.
I've narrated the sequence.
So chronologically. The dates, there's no. Page. Office objection serial number 1 is overruled. Yes, next. You have carried out. Pagination. You have to carry. Then next. Paper to be stitched. Gives it. Okay, the annexures.
So the annexures I mentioned for your part, the trial court record. And in order the trial. So the trial court record I will follow.
That counsel for the petitioner submits he has complied with all other objection except at serial number 2. And submits that he would comply with the office objection at serial number 2 within the course of today. Interim order earlier granted is extended to the next day. Yes. Respondent number? That counsel so and so submits. He undertakes to file wakalat for the respondent. That interim order. Interim order earlier granted is extended till the next date. You file the objection and you move the matter, I'll give you a date. The respondent submits that you would file objections. Matter is adjourned. Interim order earlier granted is extended to the next day. Permission copies. Already there is some interim order. office to put up, and you ask for clarification. It may be only a mistake. So correct. You can seek for clarification before the same bench. Because it looks it's a detailed order. So it looks like the interim order was passed on that day. So you file an IA seeking for clarification. It is. So now you move. So then I'll have to wait only till they come. Otherwise, you seek for clarification. That will be subject to the outcome, I can say. No notice is ordered already. That's why I'm saying you seek for clarification of this order only. It will come with effect from 20th of December. You file a memo for being spoken to, it will go before the same court, wherein there may be some explanation why get a fresh order and only adjourn it and ask the office to put up the report. Meanwhile, move the matter for clarification, file an IA for clarification. Let us see. Office to put up a report regarding notice issued to the respondents. Once notice is issued, I can't until the other side appears. List the matter week after next. You clarify that, let us see. Or if the notice is served by the next date, you move the matter. I've asked the office to verify. Learned counsel for the petitioner submits that the court by its order dated 2012-2020 that he was under the impression that the court in its order dated 2012-2022 had in fact passed an interim order. It is submitted that there appears to be some error in the order and you would seek clarification. Let us see. No representation on behalf of the petitioner. This matter week after next. Now you serve the other side. No, you serve the council. Para? No, we have appointed para 5 is clear. Yeah. It's fine. 2022. Teaching for modification of the final order on the ground that it is noted that an arbitrator from Mysore has been appointed to enter into reference. However, there is a further observation which gives the impression that proceedings are to be held at Bangalore, isn't it? That the venue of arbitration is at Bangalore. Mr. Taking note of the stand of both the council, we submit that the seat of arbitration should be at Mysore, and rightly the court has appointed a retired district judge from Mysore to enter into reference. Observations giving an impression that the seat of arbitration would be at Bangalore is to be substituted by clarifying the same to be at Mysore. Accordingly, the order dated so and so is modified as follows. In para 5, delete the words after the word sole arbitrator. Till the word governing, till the word, delete the following words. After the word sole arbitrator, inverted comma, in the present case, in the Arbitration and Conciliation Center, Domestic and International, Bengaluru. Further, delete the observation made at Roman 2 and substitute it by the following clause. The seat of arbitration would be at Mysore, and the fee schedule and other matters would be as per the rules governing the Arbitration and Conciliation Center at Bengaluru. Rules only. Yes.
Okay, go to the draft. 48.
No, what I mentioned a colleague, let the proceedings go on. I'll make it subject to, and we'll decide the matter. Why stay the matter? No, what I'm saying is, I don't want to stay any matter. We'll correct it afterwards. Well, let us see. I'm saying, why stay the process? No, we'll reopen the whole thing if case is made out later.
Then we will be having a problem. And in the case where all the amendment that the only respect of the source, the matter is the problem.
The suit of 2013. The court doesn't have time. That's the problem. Is in every matter if we stay the.
How that the responsibility is but all I have it, I will always do that. Otherwise, you may also agree to all.
So that's why we're saying let the proceedings go on. We'll rectify it.
What should be my case?
No, we'll rectify it if there is any.
Documents are marked.
No, now let the preliminaries be completed then.
Yes.
Who has died? Who has, what happened in the trial court? Whether the respondent number 2's LRs are not on record? No.
Mistake. I can understand not only understanding being for the first time with the victim is taking the walk. It is not for the first time. After 8 years, 3 things is specific. Please keep it.
I am ready to argue that.
No, now the solution is let him be permitted to lead evidence even with respect to the proposed amendment. So just one. Then we'll expunge it later. Let us. It is submitted that second respondent has died. Necessary steps to be taken forthwith. Notice has gone, not yet. Just 1 minute. Let the higher notice must go.
For the last, the whole purpose, responding. The whole purpose is dictated. Please raise it for a while. If this kind of this is adopted, no proof will come to an end.
No, let the why stay of proceeding?
I think also the course of my cross-examination, whatever I was trying to say in the way that has been suggested by the other side is their case also. Ultimately, judgment is allowed. No prejudice to be crossed. In fact, I can read this cross-examination opinion of even I mean, really they have suggested the same thing. In according to the 1942, there is a legislative way. So ultimately, the controversy is only this. But whether I am only trying to say directly the source of title of the property. It is a joint family property according to me. Whether it is a joint family property or not, it is a matter of time. But the source of the house is not required.
Now, who are the proposed LRs?
The wife and the children, unset and good order.
He submitted that.
Required evidence and summons order.
Submitted that respondent number 2. Died on 9/9/2022. Accordingly, IA and order 20 under order 22 has been filed. Issue notice to legal proposed legal representatives of respondent number 2. Petitioners at liberty to take out notice by way of hand summons. It should be in addition to emergency notice through court. This is the matter week after next. Now we have to decide the matter.
We have been enjoying the stay for 5 years. 2030. There's no problem. We can't just, I am not just asking for the head of one of it. Therefore,
Let the LR come and record. Now, how do we decide it without LR? I agree with you. I agree. I am with you, but somebody has passed an order. I can't overlook that order. No, we'll consider it. No, get ready. Let us see. No, I'm aware of your concern, and even I am.
2030, before that, till 2011, and they lost the entire thing.
Let us see. Let the preliminary. Let the preliminary. Then we'll take it up. I agree with you. That's why I'm not inclined to stay in any matter. The order of stay has been passed.
My lord.
Just 49. What is the year? No, we'll hear it, but now R2 somebody must represent this. How we can? We'll see then.
Number 49.
Date. List the matter on 19. List the matter on 19. 19. Yes, next.
49.
Yes, next.
My lord, I appear for the petitioner, my lord, in this case. Notice to the proposed LRs of R9 may be ordered, my lord. So far as non-compliance is concerned, a week's time may be granted. I will look into it and R9
to be complied with by the next date. Issue notice on IE 1 of 22 to the LRs of R9.
Much obliged.
Number 50.
What is the order that is challenged? What is the order that is challenged? This is a stamp duty. And then we'll only stay that order, let the proceedings. No. Why you should stay the suit because of stamp duty? That order I'll stay. You don't have to pay stamp duty. That we'll hear. No. This we can't in the CPC matters. When Tariq pe Tariq, I'm not ready to do that. I'm going to stay that order. Further proceedings, there's absolutely no warrant to stay further proceedings. No. I'm not ready to argue the matter here. I want to know why you want stay of the trial court proceeding. Now you have challenged the order regarding imposition of duty and penalty, isn't it? Now that is something we will decide. So that order I'll stay. Let the proceedings go on. This order I will stay. So you have no obligation to pay. We'll hear both the sides whenever you want and we'll hear. But let not the proceedings of the suit be stopped. No. Why I should give you a mask? That is a different matter. I am telling you that the order that is passed is regard. What is the impugned order? That is stamp duty. So what I'm saying, I'll stay that order. Insofar as proceeding with the trial court, let it go on. I'll have it next week to argue. Your interest is taken care of by stay of the impugned order. Why stay the suit proceeding? The impugned order is at page. Page 16. Now you are required to pay the stamp duty, isn't it? Correct. So that order I'll stay. Let the proceedings go on. We'll decide this writ petition. No. Then there's no point in rehearing the matter. I'm only going to convert this into a stay of the impugned order. And then I'll have it next week. You get ready and come. Why you require a stay of trial court proceedings? That is different. Let that. That is okay. That you can do it. That you can do it. Now, if you stay the impugned order, you are permitted to rely on it also. So there will be no prejudice caused. Tomorrow, suppose finally it's an important document for you. Either you have to pay, isn't it? Or the court may set aside the duty and penalty. So let us not stay the proceedings of the trial and stay this order. By virtue of that, the proceedings can go on. We'll hear this. You get ready on the main matter. No, that's not a hassle. That's the main thing. It is noticed that petitioner has challenged order on payment of stamp duty and penalty passed by the trial court. Learned counsel for the respondent submits that the proceedings of the trial court may be permitted to continue while permitted to continue. It is deemed appropriate to pass an order that the impugned order which is challenged in the present proceedings may be stayed, while clarifying that the proceedings before the trial court could continue, while making it clear that the same would be subject to orders to be passed eventually in the writ petition. Deal is the matter next week. That I clarify.
for matters, number 6, correct? Pending.
It's the matter next week. A request of
Court officer serial number?
petitioner.
6, serial number 6. Serial number 15, let me.
This is a concurrent finding. No? Okay, let us see. We'll hear the other side and then pass. No, let us see. Let us see. We'll hear the other side and dispose it of once and for all. No ex parte order. You take out notice and then you move the matter. In their presence, we'll see what is to be done. You first show me the IA, let us see. This is the IA filed before the trial court. Not to alienate. This is IA number 2 of 17. Yes. Page 20. Now this is this MA is filed against IA 2 of 17. Yes, yes. Yes, yes. The counsel for the petitioner submits that though the application IA2 of 2017 was filed against the defendants seeking for an order restraining alienation by the defendants and what happened to that IA2 and against the dismissal of said IA, MA was filed. However, in the miscellaneous appeal, contrary to the relief sought for in IA2 of 2017, the appellate court, while disposing of MA 22 of 2018, has passed an order restraining the defendants from interfering with plaintiff's possession and enjoyment of the suit scheduled property. It's pointed out that the appellate court could not have gone beyond the relief sought for in IA2 of 2017. In light of there is a substantial merit in the plea put forward by counsel for petitioner. Accordingly, subject to further consideration, there would be stay of the impugned order in MA 22 of 2018. Issue notice to the respondents. Petitioner is permitted to serve counsel appearing for the respondents to the trial.
I appear for the petitioner, my lord.
Now you appear for all the respondents.
No, the cavator is for the first respondent. The second and third respondent notice will have to be dispensed because there is no prayer sought against the BBMP, my lord. The application was by the respondent number 1 only.
Yeah. Yes. No, let him proceed.
Yes, my lord.
Yes, petitioner, you can proceed.
Yes, my lord. The petition was filed by the respondent number 1 initially for bare injunction. An order of temporary injunction was granted ex parte. Subsequently, application for vacating was moved and the order was modified. Thereafter, issues was framed. It was posted for evidence, and the respondent number 1, that is the plaintiff, files an application for amendment, seeking amendment of pleadings as well as the prayer and the schedule. That came to be allowed, which we agreed, and we filed additional written statement. Thereafter, additional issues was framed. After
So where is the first order?
Amendment
Or-
allowed, that has not been disputed. That is allowed, my lord. They have
That's
filed
in which year? Which
the-
year?
in 2016. I have filed the amended plaint. Amended plaint is at page, my lord, page 34. Amended plaint was filed by them. We had not challenged that order.
What was the amendment that was made at the first instance?
First instance, the pleadings, my lord, that is at page 35. Page 35, paragraph 3A. 3A. This was the amendment. The plaintiff submitted that the plaintiff is the owner of the Schedule B property, having purchased from one so and so. There is the northern portion of the property, the plaintiff in Schedule B property, and south portion of the Schedule A property. The defendant number 3 is putting up construction by encroaching without leaving setback towards the northern side of the plaintiff property, measuring 146 feet, which is being constructed illegally, which has to be demolished to bring the building within the purview of the sanction plan. And also at page 37, the Schedule B property was added, and prayer was also added. Prayer for C1, that is at page 37, my lord. For direct the defendant number 1 and 2 to demolish the unauthorized construction built on the northern side of the plaintiff property. The plaintiff and the petitioner and the first respondent are neighbors. The petitioner had constructed the building as per the sanction plan. BBMP was also made a party in the suit. The BBMP had taken necessary action against it, which was complied with. But still, this defendant initially he had sought for bare injunction. Once we complied with the BBMP and constructed the building, everything, subsequently he claims that we have encroached the property and then sought for amendment and direction to demolish the portion of the B schedule property, which comes within the purview of the respondent number 1. That was allowed. We filed additional written statement and additional issues was framed on it. Evidence was started. Evidence was commenced way back in 2022. They completed the evidence. Documents were marked. Witness were examined. After completion, the matter was posted for final argument. At this stage, the respondent files an amendment application of the pleadings as well as the prayer, because in the cross-examination he admitted to certain facts that there was no encroachment on his land as far as his land. And as far as there is violation of the building plan or I have constructed, it is for the authorities, the BBMP authorities, that is respondent number 3 and 4, to take action against me. Now he says that I have encroached his portion and then constructed. At this stage, at the final argument stage, he is my neighbor. 6 years after the first amendment, he makes a statement in his affidavit along with the IA that recently, when I saw the property, the engineers came and measured the property, which says there is an encroachment. After 6 years, he is being my neighbor, staying there. And he says where there is due diligence in this matter for IA to being allowed. The Supreme Court time and again has said that amendment should not be allowed at the stage once the trial commences. And moreover, only in extraordinary cases where due diligence has expressed in number of decisions where it was inappropriate or not possible for the plaintiff or the party who files an application could not have filed earlier. And what are the parameters at what stages the amendment applications has to be allowed.
Now, what is the proposed amendment?
Proposed amendment is from page 71, my lord. Page 71. In the order on IA itself, the trial judge extract the entire pleadings from page 71, my lord.
Just read it. Let us have a look at it.
From page 71, proposed amendment sought for. My lord, got it at page 71, my lord.
Yes, yes, yes.
To incorporate para 8A to para 8G after para number 8 in the memorandum of plaint as under. The plaintiff humbly submits that at the time of filing of the suit, the defendant number 3 was putting up the construction and he had not completed the construction, the entire building during the pendency of the suit without securing any permission from the Honorable Court. The defendant number 3 has completed the construction after a couple of years. The plaintiff humbly submits that he has stated in his plaint that defendant number 3 has encroached his property. The defendant number 3 is putting up construction which is quite contrary to the terms of the sanctioned plan. There are deviation in the construction put up by defendant number 3 on the southern side of the property, namely the northern side of the Schedule B property. 8B. The plaintiff humbly submits that few days back, he was unable to ascertain the extent of deviation of his property, namely an area measuring 1.5 feet on the northern wall on the eastern side and 9 inches on the southern wall on the western side, namely 18 plus 9 inches divided by so and so equals 56.3 feet, which is encroached area in the Schedule B property, which is more fully described in the schedule here and there as Schedule C property. The plaintiff could not incorporate this area in the plaint at the time of filing of the suit, since defendant number 3 was putting up construction. Under these circumstances, it has become necessary of the plaintiff to kind the notice of this Honorable High Court to enable the Honorable Court to give necessary direction to the defendant number 3, for which I have sought for a decree of injunction in this plaint. 8C. The plaintiff humbly submits that even though he has stated that there is an encroachment on the northern side of his property, but he was unable to incorporate the same at the time of filing of the suit, since the construction put up by the defendant number 3 was progressing day by day. As such, he was unable to specify area with regard to deviation. 8D. The plaintiff humbly submits that a few days back, he was able to ascertain about the extent of deviation made by defendant number 3 in his building. The plaintiff submits that the defendant number 3 has extended the balcony on the property of the plaintiff. There are 4 floors built on the Schedule A property, and on each floor there exist 7 balconies toward the northern side of the Schedule B property. As such, it is necessary for the Honorable Court to direct the defendant number 3 to remove the balcony area which is lying on the property of the plaintiff by granting a decree as prayed for in the plaint. And if the defendant number 3 fails to do so in the spite of there being a decree by this sort, defendant number 1 and 2 be directed to demolish the game by granting a decree of mandatory injunction as prayed for by the plaintiff. B, then BE, 8B. The plaintiff humbly submits that he has stated in this plaint that the defendant number 3 has put up unauthorized construction in the building put up by defendant number 3 on the Schedule A property. The plaintiff humbly submits that the defendant number 1 and 2 have permitted the defendant number 3 to put up construction, namely stilt floor, ground floor, and second floor, and a portion in the terrace area, whereas defendant number 3 has put up third floor, which is not sanctioned by BBMP. And he has also put up construction on the terrace of the third floor, which is clear, unauthorized, and illegal construction. These things could not have been incorporated in the plaint at the time of filing of the suit, since defendant number 3 was putting up the construction and he completed the construction subsequent to filing of the written statement and additional written statement. Under these circumstances, it has become necessary for plaintiff to bring to the notice of this court with regard to the unauthorized construction put up by defendant number 3, which is quite necessary and essential for the Honorable Court to adjudicate the same for consideration of the reliefs paid in the suit. 8F. The plaintiff humbly submits that the extent of deviation made by defendant number 3 in his property during the course of putting up construction as aforesaid, and the said enclosed portion is more fully described in the schedule to the memorandum of plaint as Schedule C property. 8G. The plaintiff humbly submits that in the event of this Honorable Court does not direct the defendant number 3 to remove the unauthorized construction specified in the Schedule C property of the plaint, in which event the plaintiff will be unable to enjoy his property, namely Schedule B property, since the flow of air and light on the northern side of the plaintiff property. within the bracket, the southern side of the property belongs to defendant number 3, will be affected to a larger extent, and the value of the property will also be diminished in terms of money also. Second incorporation, to incorporate para 9A after para 9 in the memorandum of complaint, the plaintiff humbly submits that the events which are stated at para 8A to 8G in the plaint have taken place subsequent to institution of the suit and during the pendency of the suit on various dates. As such, the events which have taken place in the scheduled property are more fully described in para 9 and para 9A of the memorandum of complaint. To incorporate para number 10A after para number 10 in the memorandum of complaint as under. The plaintiff humbly submits the plaintiff has sought for a decree of mandatory injunction directing defendant number 3 to remove and restore the enclosed area and also deviated portion and demolish of unauthorized construction, namely the third floor construction put up by defendant number 3 on the northern side of the scheduled property. The plaintiff prays for a decree by way of decree of mandatory injunction in respect of the Schedule C property, and he values the said relief of decree mandatory injunction under section 26C of the Karnataka Court Fee and Suit Valuation Act in a sum of rupees 1,000, and accordingly he has paid the requisite court fee also. The plaintiff humbly submits that the plaintiff has also sought for a decree of mandatory injunction directing the defendant number 1 and 2 to remove the construction specified in the Schedule C property to the plaintiff in the event of defendant number 3 omits to do so on merit in spite of there being a decree which may be passed by the Honorable Court, thereby directing defendant number 1 and 2 to remove the same and recover the cost from defendant number 3 in this regard. The plaintiff values the said relief of decree of mandatory injunction under section 26C of the Karnataka Court Fee and Suit Valuation Act in a sum of rupees 1,000, accordingly has paid the requisite court fee. To incorporate the prayer E and F as under, grant a decree of mandatory injunction, thereby directing defendant number 3 or any other person claiming under him to remove the construction put up, namely the deviated portion, and for removal of the deviation portion, namely the 7 balconies in each floor, and to restore the deviated portion to the plaintiff as stated in the Schedule C property. Direct the defendant number 1 and 2 to remove the construction specified in Schedule C property to the plaintiff in the event of the defendant number 3 omits to do so on merits in spite of there being a decree which may be passed by this Honorable Court, thereby directing defendant number 1 and 2 to remove the same and recover the cost from defendant number 3 in this regard. To incorporate Schedule C property after Schedule B property in the memorandum of complaint as under. Schedule C, an area of 1.5 feet on the northern wall on the eastern side of the Schedule B property and 9 inches on the northern wall on the western side of Schedule B property, namely 18 plus 9 inches divided by 2 by 50 feet, totally 56 feet, which is encroached area in the Schedule B property, and to restore the same to the plaintiff. 2.7, that is second prayer. 7 balconies on each floor, namely 4 floors, constructed on the Schedule A property by defendant number 3. In all, total 28 balconies, which is stretching on the B schedule property belonging to plaintiff, and to restore the same to the plaintiff. Removal of the unauthorized construction put up by the defendant number 3 on 3A on 3rd floor on the A schedule property. These are the amendment which has been sought, my lord. So many balconies was not constructed overnight or over a period of time, which was completed long back, and some of the flats are already being sold by the petitioner. In fact, almost all the properties or flats are being sold by the petitioner. Long back, they are living from 4 or 5 years. And the respondent number being the neighbor, it is not overnight it was constructed and balconies came up over 4 floors, 27 balconies. He could have done this at the stage of his evidence or before evidence. Evidence was commenced only lately in 21-22. At that stage, in fact, the petitioner had sold the properties, everything. Entire balcony was, if at all there was any deviation, the appropriate authorities, that is BBMP, who is also a party in the suit, will take necessary action in that regard. He only came up with this plea that I have encroached his portion. If that is so, from 2016 when the suit was filed, if that encroachment was there, he could have raised even when he made a first amendment. This encroachment was totally a fresh plea taken up in this amendment.
Yes, read from para 8 onwards.
Yes, my lord. Yes, my lord. According to the plaintiff, he is intending to plead the facts by way of proposed amendment which have occurred subsequent to filing of the suit. According to the plaintiff, at the time of filing of the suit, entire building of defendant number 3 was not completed, and as such, he was unable to calculate what is the encroachment made by defendant number 3 on his property and the deviation with regard to the construction activities carried on towards the northern side of the property, that is southern side of the defendant number 3 property. According to the plaintiff, about few days back, he was able to look into the property belonging to defendant number 3, and with the assistance of qualified civil engineer, he was able to ascertain the detail about the extent of deviation, the number of floors where the construction put up by defendant number 3 on the southern side of his property, and the extent of deviation, which is quite contrary to the sanction plan secured by the defendant number 3. Hence, the plaintiff has contended that those subsequent facts are to be brought to the knowledge of the court by amending the suit claim. Next paragraph. Further, according to the plaintiff, he is also intending to seek additional relief of injunction against defendant number 3 to demolish the unauthorized construction. This application is objected by the defendant number 3 mainly on the ground of delay. According to the defendant number 3, the matter is now posted for arguments, and the plaintiff has filed the present application after commencement of trial, and when the matter is posted for arguments, only with an intention to prolong the matter. Further, defendant number 3 has contended that he has put up construction work as per the modified order by this court on in the year dated 15/2/2014, and the plaintiff has filed the present application only to harass the defendant. Further, according to defendant number 3, the proposed amendment will change the nature of the suit and the cause of action, and the additional relief as sought by the plaintiff in the proposed amendment also cannot be granted. Next paragraph. As it is rightly contended by the defendant number 3, the proposed amendment is sought by the plaintiff when the matter is posted for final arguments. Under Order 6, Rule 17 of CPC, the application seeking the amendment of the plaintiff after commencement of the trial on the case cannot be entertained unless the plaintiff has shown due diligence. But the Honorable Supreme Court of India in many cases has held that amendment application filed after commencement of trial can be entertained. The Honorable Supreme Court of India in the decision of civil appeal number so and so between Pandit Malhari Mahale versus Monica Pandit Mahale and others, disposed of on 10/1/2020, has held amendment after trial can be allowed under specific condition. It is further held that unless court is satisfied that plaintiff could not have raised the issue in the amendment application at the stage of prior to commencement of trial, despite due diligence, the court cannot allow the amendment after commencement of trial. It is further held that there should be finding of the court that it is satisfied that in spite of due diligence, the party would not introduce amendment before the commencement of trial. In the recent decision of the Supreme Court of India in Life Insurance Corporation versus Sanjeev Builders Private Limited, disposed of on 1/9/22, reported in 2022, so and so, the Honorable Supreme Court of India has laid down condition for allowing the amendment after commencement of trial of the case. It is held that all the amendments are to be allowed which are necessary for determining the real question, and it does not cause any injustice or prejudice to the other side. The amendment which is required for effective and proper adjudication of controversy between the parties can be allowed. But the Honorable Supreme Court of India in the said guidelines has also held that the amendment seeking the withdrawal of admission, and if the claim made in the amendment is barred by law of limitation, the amendment which changes the nature of the suit, if prayer for amendment is nullified, if the amendment changes the nature of the suit or cause of action so as to set up the entirely new case, foreign to the case set up in the case, must be disallowed. Next paragraph. From the aforesaid two decision of the Honorable Supreme Court of India, it is clear that the application seeking amendment of the pleading can be entertained even after commencement of trial. The court has to satisfy that the proposed amendment is necessary for proper effectful adjudication of the suit, and the court has to satisfied that in spite of due diligence of party, he has not pleaded the said fact before commencement of trial. Next paragraph. It is to be noted here that this suit is filed by the plaintiff for relief of permanent injunction, order against defendant number 1 from putting up unauthorized construction of the building and from encroaching the plaintiff's compound wall on the southern side of suit A scheduled property, and seeking direction to defendant number 1 and 2 to demolish the building and to bring it within the sanction plan and bylaws of BBMP. Further, the plaintiff has also sought for the relief of direction to the defendant number 1 and 2 to demolish the unauthorized construction building on the northern side of the plaintiff's property. The plaintiff in the suit plaint has averred that he is the owner of the suit B scheduled property and defendant number 3 is the owner of the suit schedule A property. The plaintiff has alleged that the defendant number 3 is putting up construction by encroaching his property measuring 140 feet. It is also alleged by the plaintiff that the defendant number 3 has violated the building bylaws and he is not putting up construction in A scheduled property as per sanction plan. The plaintiff has also erred, I think, it has to be read, erred that the defendant number 3 has encroached the plaintiff's common wall and also constructed the apartment unauthorizedly on the southern side. Next paragraph. Now, by way of the proposed amendment, the plaintiff is intending to plead the fact about the continuation of construction by the defendant after filing of the suit in the suit A scheduled property. Further, the plaintiff is intending to plead the fact about measurement of deviation made by the defendant and measurement of the property encroached by the defendant in B scheduled property. The plaintiff is intending to introduce separate C scheduled property in the suit plaint, which according to the plaintiff is the encroachment done by the plaintiff in the B scheduled property belonging to him. Further, by way of proposed amending, the plaintiff is intending to plead the subsequent events which have occurred after institution of the suit. The plaintiff is also seeking the additional relief of mandatory injunction against defendant number 3 to remove illegal construction put up by him in the C scheduled property and seeking direction to the defendant number 1 and 2 to remove the illegal construction in the C scheduled property. The proposed amendment sought by the plaintiff is very much concerned to the facts pleaded in the suit plaint. Further, by way of proposed amendment, the plaintiff is intending to plead the subsequent facts which have arisen out after the institution of the suit. Since the suit is for the relief of permanent injunction and mandatory injunction, the description of exact encroachment alleged to have been done by defendant number 3 is very much necessary. The plaintiff, by way of proposed amendment, wants to plead the exact measurement of encroachment done by the defendant number 3 and deviation done by the defendant. The proposed amendment will not change the nature of the suit or cause of action. The proposed amendment is very much essential and required for proper and effectful adjudication of the suit. Further, the proposed amendment is also necessary in order to avoid multiplicity of the proceeding. Since the plaintiff is alleging that the defendant have encroached his property, that is B scheduled property, it is necessary for the plaintiff to seek additional relief of mandatory injunction to remove the said encroachment. If the proposed amendment is not allowed, the plaintiff has to file another suit and it will lead to multiplicity of proceedings. In order to avoid multiplicity of proceedings, I am of the opinion that the plaintiff can be given an opportunity to amend the plaint and to seek additional relief and to plead the subsequent fact which, according to the plaintiff, took place after institution of the suit. The Honorable Supreme Court of India, in the aforesaid decision, has also clearly held that the proposed amendment after institution of suit can be allowed if the proposed amendment is necessary for proper, effectful adjudication of the suit and to avoid multiplicity of proceedings. Whether the suit filed by the plaintiff is maintainable or not, and whether the relief as sought by the plaintiff in the suit plaint or in the amended pleadings can be granted or not, as contended by defendant number 3, has to be adjudicated only on the merits of the case. Further, whether the suit filed by the plaintiff seeking the relief of easementary right of necessity or not, and without seeking relief of declaration of infringement of civil rights or not, as contended by the defendant, has to be adjudicated only on the merits of the case. This matter is of the year 2014. The matter is now reached fag end. It is now posted for argument. The reasons for delay in filing the application is not properly stated by the plaintiff. Only on the ground of delay, the application cannot be rejected. The delay can be compensated by imposing cost if the proposed amendment is allowed. No hardship or injustice will be caused to the defendant for the delay, inconvenience, and hardship caused by the defendant. And the application can be allowed by imposing cost. If the application is allowed by imposing cost, the defendant will get an opportunity for filing additional written statement, and he will also get an opportunity of cross-examining the plaintiff witness on the amended pleadings. Under these facts and circumstances, I am of the opinion that the proposed amending application can be allowed by imposing cost in order to avoid multiplicity of proceedings and to adjudicate the dispute effectually and once for all. Hence, I do not find any merits in the objection filed by the defendant number 3. Hence, I am of the opinion that the application filed by the plaintiff praying for amendment of the suit claim can be allowed by imposing cost. Accordingly, point number 1 is in affirmative. Point number 2, in view of my findings on point number 1, proceeding to pass the following order. IA number 8/22 filed by the plaintiff under order 6, rule 17, read with section 157-51 of CPC is hereby allowed with cost of rupees 2,000 for amendment and amended plaint. Now the amendment plaint has been filed. Case is posted for a filing of additional written statement, my lord, day after tomorrow.
Yes. Yes, what do you say?
The petitioner has already read the document. Speak about the modified temporary injunction.
No, so what is the, why the delay and what is the nature of injunction? The nature of injunction is amendment is twofold. One, insofar as the balconies are concerned, which you say has been done during the pendency of this. Then what about Schedule C? You're saying there's an encroachment of B scheduled property by him.
So, on the day of filing this, the construction was just started. So, during the pendency, the construction was going on, and on the northern side of the petition, respondent one's property is where the petitioner's property is there. So, the temporary injunction was first on the entire Schedule A property, whereas later it was modified. Petitioner shall not construct or shall not want the construction on the southern side of Schedule A. Petitioner's property. Irrespective of there being a temporary injunction order given by the court below, they started constructing on the southern side of the Schedule A property. And during the pendency of the suit, they continued the construction. And as the petitioner has said, in the year 2016, we sought for an amendment, and there, if you honors me, I would like to draw your attention to page number 35. In the writ petition, page number 35. There, in para 3A, 8th line, you mentioned that defendant number 3 is putting up construction by encroaching without leaving the setback towards the northern side of the plaintiff property, measuring 146 feet, being construction illegally, which is to be demolished to bring the building within the purview of the sanction plan. On that day, the construction is still happening. They had not finished the construction. Moving on to their additional written statement, which is filed with this amended claim, I'd like to draw your lordship's attention to page number 43.
Yes.
They have clearly mentioned that in the first line that as per modified the order of honorable plaintiff in the present suit does not see any right to it. So in both in the WS and in the additional WS, they have never stated that the construction is completed. All that they're saying is it is almost in the fag stage of construction. And moving on to the next point, they said that the construction is according to the bylaws of BBMP. So the BBMP have already taken action against section 321, wherein the petitioner themselves went to KAP, filed an appeal, and the same was dismissed. And now they have also filed a review petition, which they have not contested so far. And now that is in argument stage, and that is still pending. Having all this, I would like to move on to the IA, that is reviewed order that is
So their contention is this encroachment into B scheduled property. You could have raised at an earlier point of time.
The balconies were still being constructed. Before it was just the actual construction that was put up, and later they started putting up the balconies on the Schedule A property. That was the reason why even during our 2016 amendment, we could not actually seek for a prayer for not actually say what is the actual measurement of the balconies that were constructed.
In 2016 itself, in my additional written statement, I have said that I have completed the construction in 2016 itself.
Let us see. Let her complete. Let her complete.
I'm sorry.
Yes. Yes.
And then in both written statement and additional written statement, nowhere they mentioned that the construction is complete. They mentioned it is about to complete and it's at its stage of completion. And moving on to the present impugned order, I would like to bring you to your honor's notice as to the imposition of the cost. So a cost of rupees 2,000 was imposed on IA impugned order as well as on IA 622 and IA 7 2022. On 8th of December 2022, respondent number 1 entered their cost and the same was received by the present petitioner without any protest. And this itself shows that they showed their acceptance to the impugned order and basically they gave their effect to the said order. And after 9 days from that date, I mean to say on 17th December 2022 is when they filed this writ petition saying that such and such order is not in their favor. So this aspect of them receiving the cost and giving an effect to the same order is not in any part of this petition. Moving on to the next point, Your Honors, they were also on 16th of December 2020, from 8th December 2020, matter was adjourned to 16th December 2022 for filing of additional written statement if any. So on 16th December, the present petitioner comes up with an application under section 148 of CPC seeking for time to file his written statement. And in the memorandum of facts that is filed.
That's okay. That is again procedural. Now they had to get the writ ready and filed. So that's why they would have taken time or so. But his main contention is that you have waited too long and that the building itself was completed much before and you waited for a long time before you filed this, for which there is no explanation.
No. Even after the first amendment was made, the construction was still happening. Even when the present respondent number 1 led his evidence, the construction was still happening. So there were like minute changes that they kept promising to be done. And even when the BBMP took actions, even they have undertaken to demolish that part of the construction. So, but later they said that no, they've already constructed the building according to the bylaws. And that was when the actual measurement was finalized, saying this is the actual deviation, this is the actual scheduled B property becoming corresponding number 1.
When did that happen? Roughly when?
So, the action taken by authorities against the present petitioner was started from 2014. From that day, several notices were sent to the present petitioner, and they also filed an appeal before the AAT or appeal number 329 of 2015, which came to be dismissed on 19th of March 2019. And the observation made in that appeal is that they have not constructed it according to the bylaws, and it was also dismissed for on limitation basis. And then they filed a review petition saying that so-and-so order is not in their favor and they challenge it. So even till 2019 and even to this day, they have been promising the municipal.
What happened to the review petition?
It is in the argument stage, Your Honor. Even to this day, they have been promising the municipal authorities that yes, there is deviation that has happened. They've also undertaken to demolish the deviation that has been done, and they have undertaken to demolish those balconies.
Where is that? They have given in writing.
Yes, Your Honor. It was filed before the assistant executive engineer.
You have?
Okay, I just have your.
Yes, anything else? Yes, petitioner.
My lord, as far as if there is a deviation or if they have constructed illegally, it is for the other respondent BBM authority to take action which is suitably defended by the petitioner. I am not on that view, my lord. The petitioner, the respondent one being the neighbor, owner, he led when throughout his evidence when he closed his evidence, not even an iota of statement made that they have encroached my portion. Not even an iota of evidence in his entire pleading, in his entire evidence, has said that they have encroached my portion. His only contention was that the building which has been constructed is violated, bylaws are being overlooked, the BBMP authorities have made, all those things are this thing. But this fresh pleading of encroachment on his property came only when he came with his engineers to measure after 6 years. And that balcony is now built over 4 floors. Now we came to see has been seen by him that balconies have been encroached upon on his property. Now, after evidence, completion of cross-examination, everything is over. At this stage, my lord, I humbly submit that at this stage, there is a delay. There is no due diligence of the respondent on filing the application. If there was anything, so I would not have come in the way, my lord. The Supreme Court has said time and again, parameters have been formed when such an application can be allowed. May I read one citation, my lord? What are the parameters?
Yes.
Under which circumstances the amendment application has to be allowed. Following, this is reported in 2010, 1 AR Karnataka, page 29. Whether the amendment sought imperative for proper and effective adjudication of the case. That is 1. 2. Whether the application for amendment is bona fide or mala fide. 3. The amendment should not cause such prejudice to the other side which cannot be compensated adequately in terms of money. 4. Refusing amendment would in fact lead to injustice or lead to multiplicity of litigation. 5. Whether the proposed amendment constitutionally or fundamentally changes the nature and character of the case. And as a general rule, the court should decline amendments if a fresh suit on the amended claims would be barred by limitation on the date of application. These are some of the parameters which Supreme Court has said. Following that decision, there is one more from the Supreme Court, my lord, where it says that delay that is the Supreme Court reported in 2009. Amendment sought after plaintiff has filed affidavit in lieu of examination in chief, grant of leave by High Court to amend a written statement liable to be set aside. Moreover, trial court's order refusing amendment neither suffered from jurisdictional error nor an error of law, interference with the order in writ jurisdiction improper. This is where in this case where the trial court had rejected, the party had challenged it before the High Court. The High Court had reversed that order. That order was taken up before the Supreme Court. But Supreme Court said no, the trial court was right in refusing the amendment, where various cases have been discussed and referred. Here, my case is he was aware. Evidence in evidence he could have stated there was an encroachment or there was on his property. As far as his plea of the building is constructed bypassing the bylaws or by building is constructed not in accordance with the plan, it is for the authorities to look into it, for which we are very well bound by it. But now
I'll dictate at 2:30.
Much obliged. ನಮಸ್ಕಾರ ಗೌಡ್ರೆ. ಈಗ ನೋಡ್ದೆ 11ನೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಿಮ್ನ. ಅದೇ ನೋಡ್ದೆ ಇವಾಗ ನಿಮ್ನ. ನಿಮ್ ಮದರ್ದು ಕಂಡೋಲೆನ್ಸಸ್ ಏಜ್ ಆಗಿತ್ತಲ್ಲ. ವೆರಿ ಗುಡ್. ಹನ್ನೊಂದಲ್ಲಿ ನೋಡ್ದೆ ಇವಾಗ.
Arvind Desai.
Lord,
Anything else? Yes, any other submission?
I may draw your attention to page number 41 of the writ petition. That is the additional statement filed by the page number 41.
Yes.
Paragraph number 3, last 5 lines. The defendant number 3 says, thereafter, this defendant continued with the completion of the construction without violating his new order and completed the construction of the building except the portion restrained by the Honorable Court as per modified order dated 15/2014. This contention taken by the defendant number 3 itself shows that he himself is saying that the construction is not complete on the southern portion of Schedule A property. I mean, the northern portion of Schedule A property towards the site of respondent number 1. So when he himself has accepted the fact that yes, the construction is not yet completed and it is pending, the respondent number 1 at no point of time had a chance to say what was the actual encroachment and what was the actual deviation that taken place. Right from the filing of claim and the additional claim, you've been saying that the construction is not according to the bylaw and there is encroachment that is happening. Provided only after the construction got over was when the respondent number 1 was able to actually ascertain what is the actual measurement of the encroached area as well as how many balconies are as such not constructed under the bylaws.
When was the building completed?
The building was still under construction even during 2018 and 19, Your Honor. And nowhere this modified temporary injunction was vacated. They, as I said, they themselves have accepted the fact that no construction has taken place on the southern side of the Schedule A block.
And consider the petitioner has called in question the validity of the order of the trial court. Dated
29th November.
29th November 2022, whereby IA number 8 of 2022 filed by the plaintiff under Order 6 Rule 17 seeking for amendment of the plaint came to be allowed. Parties are referred to as per the ranks before the trial court. The plaintiff had filed a suit OS 701 of 2014 seeking for a decree of perpetual injunction restraining the third defendant from constructing the unauthorized building and encroaching the plaintiff compound on the southern side of Suite A scheduled property, had sought for perpetual injunction restraining the defendant from illegal construction of the apartment on A scheduled property, and had sought for direction to the first and second defendant within bracket BBMP, officers of the BBMP, to demolish the building to bring it within the sanctioned plan and bylaws of the BBMP. Subsequently, it comes out from the admitted facts that amendment was permitted, whereby the plaintiff had inserted para 3A, which reads as follows, and had also sought for an additional relief in the prayer column as C Roman 1, which reads as follows.
And also the B schedule property.
B schedule property also came to be included by way of amendment, which reads as follows. Thereafter, additional written statement came to be filed. And when the matter was posted for the evidence of defendants, an application.
No, matter at the stage of arguments, final arguments.
The stage of arguments.
Yes, my lord. At the stage of arguments, IA came to the fight.
For IA number 8 of 2022, there were two IAs filed, IA number 6 of 2022 and IA number 7 of 2022. We calling the DW1 for cross-examination. The same was
But
allowed.
the stage was at final arguments.
IA number 8 of allowed. The stage as of now was for both cross-examination with DW1 and also for filing of amended plea.
It's okay, let us. And at the stage of arguments as stated by counsel for the petitioner, present amendment application came to be filed. Learned counsel for the respondent would submit that the defendant whose evidence was closed came to be allowed by virtue of allowing of IA number 6 of 2022 and 7 of 2022. So in effect, the application was filed still at the stage of evidence of the defendants. Next, it is the application for amendment, IA number 8 of 2022, which has been filed, seeks to bring out the following amendments. Repeat para at annexure E, proposed amendments. The affidavit filed in support of the said application submits that the suit was filed on 24/1/2014, and as the defendant number 3 within bracket petitioner had commenced construction and his construction was progressing, the occasion to make the amendment putting forth full particulars has accrued at a advanced stage of the suit proceedings. The affidavit further extracts governments in the written statement of defendant number 3, which narrates that building was not yet completed. So also the additional written statement of the defendant number 3 was relied upon to assert that the construction of the building was not completed.
That is as on 2016.
Next, I'll come back. Next. Accordingly, it is submitted that the plaintiff was unable to calculate the encroachment made by defendant number 3 on his property, as well as the deviations with regard to the construction activities carried on the northern side of the property, namely southern side to defendant number 3's property. Accordingly, it is submitted that only a few days prior to filing of the application, he came across the encroachment with the assistance of a qualified civil engineer. Next. It is asserted that construction has been completed without securing any permission, contrary to the sanctioned plan. Next. It is further asserted that the subsequent events which have taken place during the pendency of the suit are necessary for adjudication of the dispute in controversy between the parties in respect of Schedule A property and Schedule B property. And accordingly, application is filed. The defendant number 3 has filed detailed objections opposing the said application and submits that the defendant has continued construction and completed construction without violating the court order. After taking note of the modified order of ex parte interim order of status quo. We'll stop. Next. It is further submitted that during the course of the proceedings, an application under Order 6 Rule 17 came to be allowed on a previous occasion, amending the plaint and converting the suit from a suit for bare injunction to declaration. And the third defendant had filed additional written statement. It is submitted that evidence of the parties was recorded and case was posted for final arguments on the main petition, at which stage plaintiff has again come up with the present application seeking amendment. It is submitted that no right of easement of necessity has been sought for declaration, and accordingly, application in the context of the said framework of the suit ought not to be entertained. Next, it is submitted that application has been filed at the fag end of the proceedings when the case was posted for hearing in order to improve the case after recording of evidence to fill up lacuna. Next, it is submitted that the amendment seeks to change the nature of the suit. Comma, same is belated, filed after 7 years from date of filing of the suit, comma, there was no diligence in filing the application for the second time. Full stop. Accordingly, it is submitted that the application requires to be rejected. Next. The trial court has passed the impugned order allowing the amendment application. Which has been assailed in the present petition. The trial court, the order of the trial court has been assailed, and the counsel for the petitioner has reiterated the stand taken in the statement of objections, while further contending that the power of the court to allow an application for injunction cannot be blindly exercised. More so in the present case, where second application for amendment has been sought. It is submitted that the construction was completed long back, and application filed at the fag end is without any bona fides, and has the effect of reopening what otherwise is a concluded trial 8 years after the suit was filed. Subordinate counsel for the respondent submits that proceedings are before the other defendant BBMP regarding the violation in sanction plan, and that the delay, if any, in filing the application is essentially due to the continuance and completion of construction during the pendency of the suit, and draws attention to the statements in the additional written statement at paragraph 3.
Page number 41. Is page number 41, internal page number 5.
It is paragraph 4 or 3.
3.
Para 3. Next. It is submitted that the subsequent events could not have been brought forth at an earlier point of time, as construction continued till an advanced stage of the suit. It further submitted that the impugned order is well reasoned and need not be interfered. Heard both sides. It is the present suit has been filed by the plaintiff as against the third defendant, who is his neighbor, and the cause of action appears to be the allegedly illegal construction by the third defendant. Originally, the suit was for perpetual injunction, and the prayer has been referred to above. Written statement was also filed. Next, it is not in dispute that during the pendency of the proceedings, amendment application came to be filed, wherein amendment was effected essentially as regards to the allegation of encroaching without leaving setback towards the northern side. The additional prayer was also allowed, wherein plaintiff had sought for a direction to defendant 1 and 2 to demolish the unauthorized construction on the northern side of the plaintiff property. Next, it is also borne out from record that the application was filed at the fag end of the trial. But the question that would call for adjudication is as to whether application, even if filed at a belated stage, seeking amendment requires to be allowed. And if so, whether circumstances are so made out which require it to be allowed. The other question that would also arise for determination as to whether this court in exercise of writ jurisdiction is required to interfere with the impugned order, and lapses warranting the same are made out. Next, in sum and substance, the amendment that is now sought to be made relates to certain averments and also the prayer column relating to defendant number 3 putting up of construction, further construction on the northern side of Schedule B property, which according to the plaintiff amounts to a deviation from the sanctioned plan. Full stop. It further comes out on a reading of the proposed amendment that the plaintiff has specifically averred regarding the extent of deviation in the property on the northern wall on the eastern side and northern wall on the western side, as is detailed in the proposed amendment. Full stop. The proposed averments also state that such quantification could not be made at an earlier point of time as construction was in progress. It is stated that recently, with the assistance of an engineer, extent of deviation was ascertained, including regarding the extension of balcony on all the 4 floors. Full stop. It is further made out from the proposed amendment that the construction was completed after the filing of the written statement and additional written statement. The trial court, after noticing the proposed amendment and the arguments of counsel for the third defendant, has referred to the judgment of the Apex Court in Civil Appeal 189 of 2020, as also the judgment of the Apex Court in Life Insurance Corporation versus Sanjeev Builders Private Limited, reported in 2022, Live Law SC 729. The trial court has then gone on to allow the application while no doubt noticing that there has been delay. The crux of the reasoning comes out from para 17 onwards, where the trial court has stated that the proposed amendment is borne out from the facts pleaded in the suit plaint, and has observed that what the plaintiff is seeking to plead are only subsequent facts which have arisen after institution of the suit. The court opines that it is that looking into the nature of the relief sought for, including mandatory injunction, the description of the encroachment alleged to have been done is necessary. The court concludes that the proposed amendment will not change the nature of suit or cause of action, and that if the proposed amendment is necessary for proper and effectual adjudication of the suit and to avoid multiplicity of proceedings, same can be allowed. Next, the contentions of the petitioner that there has been delay is no doubt an aspect on record. But however, that by itself may not be sufficient to disentitle consideration of an application for amendment. The apex court in the case of LIC versus Life Insurance Corporation of India versus Sanjeev Builders Private Limited and another 2022 SEC Online SC 1128 has culled out in the conclusion paragraph at para 70 regarding the principles governing consideration of amendment application. In the present case, it must be noted that it is not in dispute that the suit having been filed in 2014, construction has continued during the pendency of the suit, including as on the date of filing the written statement, and reference to continued construction is found at para 3 of the additional written statement. It is no doubt, as noticed by the trial court, that this could have been filed at an earlier point of time. But as also noticed by the trial court, the prayer of mandatory injunction having been sought, the execution of the decree would face difficulties if there is no arithmetical measurement of the extent of deviation which is sought to be introduced by way of amendment. Insofar as the allegation, assertion regarding encroachment is concerned, if in fact there is any encroachment, the cause of action, which even otherwise is stated to have arisen during the pendency of the suit, may lead to another suit. And in order to avoid multiplicity of suit, the conclusion arrived at by the trial court is permissible. The apex court in the case of LIC referred to above has stated amongst the various principles that the considerations that may also need to be kept in mind is avoiding of multiplicity of proceedings. And this case is one such example whereby allowing of amendment would prevent multiplicity of proceedings, which would be the consequence if the amendment application is not allowed. No doubt, various contentions have been raised on merit regarding the maintainability of the suit, including non-seeking for any relief relating to easementary rights, and also that the duty is upon the respondent BBMP to take steps to remove the unauthorized construction. However, in a proceeding relating to deciding on the correctness or otherwise of allowing an amendment application, court need not enter into the merits of the eventual relief that the plaintiff is entitled to upon adjudication of the suit. Another aspect that is to be noted is the limited jurisdiction that this court has in interfering with orders passed by the trial court. Clearly, a reading of the detailed order does not reveal any jurisdictional issue requiring interference. The main contention relating to delay and completion of construction are by themselves not sufficient for defeating the right for consideration of an application for amendment, wherein the amendment that is sought for is on the basis of the same essential facts which are pleaded in the original claim, but only seek to bring forth certain subsequent developments. Accordingly, we find no grounds to interfere with the application with the order passed by the trial court, and the writ petition is rejected.
Much obliged.
Number 29, Srinivas.
Yes. Yes. You are the
on the ground that there's 10 days delay in filing the miscellaneous application. India has a total of 10 days delay. Now, whether admitted that or not, I think that CRP and it is pending to serve. CRP is pending.
no stay.
No stay.
You should have got a stay.
After issuance of notice, many attempts were made, it was not, I was able to get it. In the meantime, Commissioner and
This is in the execution process. No, what correct? What is the ground now?
For stay of this appointment of commissioner, I'm seeking only on the ground of that CRP is pending before this.
Move the CRP.
But CRP are not. So many. 3 times came out before the court. First time expiry notice, expiry stay was not granted. It is expired notice, same as last time. Respondents are not accepting the notice at all. So now paper publication I have taken. In the CRP, I have taken paper publication from whoever has not been served. Here and it is like 8, sorry, 9 or 12. Now, till then, if the court commissioner, let the court commissioner measure the property.
It will take long time.
The measurement of immediate.
Unless you get any relief in your CRP, you can't do anything else. Now, you have no defense. What only remains is carving out of shares. Now, if finally something is done, it will be, you can seek for restitution.
Restitution of rent was not done. One doctor, there is a dispute that also. There is a delay dispute. In the area also, definitely I was not the ground.
You seek your relief in the CRP, not here. You can't, there's absolutely no ground to hold this. No. That you have seeking the CRP directly. Why come here? CPC could. What does order 20? Now you under what ground you are seeking? That you seek before the CRP, not you can't seek before the trial court to CRP, CPC could. You can't seek for stay when there is no stay in the CRP. That's the only ground that is made out by you, isn't it? So I'll you reserve liberty, you move the CRP. Unless you get a relief in the CRP, there is absolutely no way you can get any relief. Yes, what do you say, Chandrasekhar?
Is only a part of it. Again, is only a part of it. Since item number 5, they have been made as a fact.
So you take out notice, we'll see. That's all.
Only contesting respondents are respondents for 1 and 2. Rest of them are responding.
Petitioner is permitted to take out notice to respondent number 1 and 2 by serving counsel before the trial court. It is also permitted to take out notice by way of hand summons to be served on the other side on the next date of hearing, and the learned presiding officer to facilitate such service of notice. Learned counsel notice to respondents number. Notice to the other respondents is dispensed with at the risk of the petitioner. Learned counsel Sri P.V. Chandrasekhar accepts notice for R14. File give a memo. Yes. Now you move the CRP. Even if it comes, don't move it. There's no point before me. Yes. Next. Yes. Next. Serial number 30. 51. 51. There's a stay, no stay.
There is a stay. Don't shoot you about it. 2010.
No representation on behalf of the petitioner. Made clear that if the petitioner remains absent, the interim order would stand vacated. Relist the matter week after next.
52. Mahesh Kiran, 52.
There is no representation on the other side.
But in that suit, also filed an application and order to comment. And the interim order was granted. State order was putting the suit and in this they prefer an MA also. Also came to discussion by detailed order. Now this super bad intention now sought to be converted for declaration. The lordship kindly see, even at the time of filing this suit, they were aware about all the safeties right from 1950.
What is the stage at which they filed the application?
It was during the commencement of the plaintiff evidence. Now my respectful submission to your lordship says, the amendment which is now sought and which is now allowed by the High Court changes the entire nature of the suit, as well as it also takes away the credibility. Subjection was raised before the High Court, not considered at all.
Let us see, read the order. Read the order.
Relevant reasons.
You read from the beginning itself.
Order on the year number 11. All the said documents are executed related and they have more knowledge of the same. The above said documents are not technically dated. It have amended. The proposed amendment is carried out no hardship. The application is not allowed to make it in hardship. The application is on the other hand, the dependent number 2 has the proposed amendment is barred by law and limitation. The proposed amendment is permitted to be allowed. This court will use the particular jurisdiction and court will take and take this. Based on this by virtue of an order.
Read para 7 onwards.
Or in any manner interfering in this. Based on the illegal argument, the defendants are not trying to. The defendants have. On the other hand, the defendants are the second defendant has made based on the clearance the issues have been raised, then the matter is set out for plaintiff's evidence. That application has been made by the defendant and not claim of trying to create by them. on the strength of meeting the documents to protect the interest of the plaintiff. They have filed clearances for organized private litigation in the claim. Plaintiffs have specifically stated that the documents which the defendants are relying on legal and document. Since the defendant number 2 has stated that they are claiming rights on the documents, it is necessary for the plaintiff's declaration to declare that the legal documents are not binding on them and say what they did. On the other hand, it is significant that the court defendants filed the years prior to bringing the application. In this limitation, it's established law that limitation is law and tax. The same should be considered Article 5 only. At this stage, when there is no clear admission of statement years from the date of the essence of that
No, but what is the prejudice that is caused to you? On merits, you can always make out your case regarding limitation. Now, evidence, it's only at the initial stage of evidence. You have the order sheet of the trial court?
Yes.
So when did the evidence start?
Because evidence was not convincing.
Issues were framed. So then that due diligence also will not come into. So this was prior to commencement of trial. But Supreme Court in that LIC case, latest one, I think don't be technical on.
The reason why I approached this one, the entire brain, from the year 1960. At the first instance, they only seek for clarification. Only after saying all the application of they come to this. That is not followed. But in that there is no cause of action also mentioned in the entire amendment. But without cause of action, all these factors were not also the ballot, but the ballot that is this has to go. And earlier, civil judge as well. All these factors are considered to be current judge, not by the application. He simply says not all those things can be considered in a later stage. Nearly 4 to 5 deeds which are related to nearly 1960s are supposed to be declaration by seeking certificate. They say it is not any of them. Regulators should say that not the registered document which has to be available by taking proper court as well. Other ಬಗ್ಗೆ there is not in a single error. Is forthcoming in the entire application. But that is not about the application. And what documents it is constructive notice. Once they are available for the registered document, the comment the very first instance of declaration of something to orders and the hands of the court.
This I'll consider. The petitioner, who are the defendant, who's the defendant number 7 before the trial court, has called in question the validity of the order passed on IA number 11 filed by the plaintiff for amendment of the plaint, which came to be allowed. The parties are referred to as per the rank before the trial court for the purpose of convenience. Next. The plaintiff had filed OS 28 of 2013 initially for permanent prohibitory injunction restraining the defendants or agents from trespassing into any portion of the plain scheduled property or alienating from or mortgaging any portion of the scheduled property in favor of third parties or creating any third party interest. The Soon after notice was issued, written statement is stated to have been filed. And insofar as application for injunction filed by the plaintiff, it is submitted that same came to be allowed. Okay, same came to be rejected by an order of 11th September 2015 and was taken up in MA 2 of 2016, and the said order of dismissal having been affirmed, it is only thereafter that application for amendment has been filed. The application under Order 6/17 has been filed seeking the proposed amendments and essentially are proceedings relating to non-binding of documents relied upon by the defendants, and that the plaintiffs are entitled to avoid the same, which cannot cast a cloud on the legal rights of the plaintiff. Declaration is also sought as regards to certain registered documents, including the deed of sale of Mulageni right as being sham, bogus, comma, and similar declaration as regards to the deed of sale of Muli rights dated 4/10/71, comma, 1/6/71, comma, deed of a declaration relating to the registered deed of settlement dated 7/2/2013, comma, deed of release dated 19/2/2013. Additional relief in the sort of declaration as regards to the above mentioned documents has also been sought for. Next, the affidavit filed in support of the said application, it is averred that these documents have been executed behind the back of the plaintiffs and are not binding upon the plaintiff, comma, that in the defense raised, objections have been taken by the defendants that the plaintiffs have not challenged the said documents put forward by the defendant, and that as the said documents are void, plaintiffs are entitled to ignore the same as they are not binding on the right of the plaintiffs. Accordingly, it is submitted to avoid future legal complications. They have been advised to seek for necessary relief of declaration that the documents propounded by the defendants are non-est and void documents and will not affect title, possession, and interest in respect of the scheduled property. Next. The defendant, on the other hand, have objected to the said application, and it was submitted that the proposed amendment is not only barred by limitation, but has the effect of changing the nature of the suit. That the proposed amendment would take away the pecuniary jurisdiction of the court, as if the amendment is allowed, the pecuniary jurisdiction of the present court would be lost, and the court would have to be, and the case would have to be tried by a court of competent jurisdiction. The next, there is no representation on behalf of the respondent, as the respondents have been served. Counsel for the petitioner, apart from reiterating the objections filed before the trial court, has submitted that the relief sought for are barred on the basis of limitation, as the documents relief with respect to which is sought for are documents executed many years back, that allowing of the amendment will have the effect of taking away the pecuniary jurisdiction of the court, and application has the effect of changing the nature of the suit. Next, peruse the order of the trial court. At the outset, it must be noted that admittedly, application has been filed before commencement of trial. The trial court has observed in its order that the aspect of limitation, being a mixed question of law and fact, is a matter that could be considered during trial. It is further observed that the question as to when the plaintiffs came to know about such of the documents are matters that could be dealt with in the trial. The courts has observed that the aspect of pecuniary jurisdiction may not by itself be a clinching factor while deciding the present application. When the application came to be allowed. Next, it must be noticed that the apex court in the case of LIC versus Sanjeev Builders Private Limited 2022 SEC Online SC 1128 has dealt with the guidelines to be kept in mind while deciding amendment application. At para 70 clause 11, the apex court has submitted that where the amendment is sought before commencement of trial, court is required to be liberal in its approach. Para 70 Roman 11 reads as follows. Next, It must be noted that no doubt there is a change in the nature of the suit insofar as a suit for perpetual injunction now upon amendment stands converted to one of declaration. However, it must be noted that if the relief cannot be granted to the plaintiff in light of certain documents that have been set up as a defense in the written statement, the plaintiff, if seeks to amend the plaint seeking appropriate relief regarding the binding nature of such documents, which according to the plaintiffs in the present case are void and not binding. Such an amendment, in fact, helps in deciding the controversy. And insofar as such application is filed prior to commencement of trial, mere changing the nature of suit from one to injunction to that of declaration may not be a sole criteria to reject the application. The question regarding delay, question regarding limitation vis-a-vis the relief also is a matter that is kept open to be decided during the trial proceedings. The mere taking away of the pecuniary jurisdiction of the court, even if it is held to be true, will not have the effect of disentitling the plaintiff to seek for appropriate amendment. As noted earlier, the present amendments are to be, which has been allowed, if has the effect of seeking certain declaratory reliefs regarding documents set up in defense. It is well within the purview of the plaintiff's right to seek for appropriate declaration. Question of merits, including the time at which such relief is sought for, are all matters to be considered during the trial. Accordingly, we set aside the order of the impugned order. Accordingly, the writ petition is rejected when the order of the trial court is upheld. Yes. Yes.
The conclusion part of it. But final conclusion it is order to CBC affect the patient may be made by the party is other side. Not raise a time bar rate. Say taking the investing of the other side of the triangle. In which case the fact that the time bar becomes the relevant amendment is the nature of the prayer for amendment the amendment we have followed on the basis of the pleadings itself can be made. A man made one request for your options. We made an application. The ground that it is as well as there is no cause of action in the entire plea. The amendment that is sought, there is no paragraph that is sought to be amended. Cause of action. So with regard to the cause of action, which is not visible. If all these three are sometimes the ancient stages, I try to find an application of
It is made clear that the observations made herein are only provisional, are only made for the limited purpose of disposing of the application, and cannot be stated to be conclusive and binding findings. And accordingly, all contentions on merits, including regarding limitation, court fee, etc., of the petitioner are kept open. That you can file, but I won't give liberty. I've stated. No, I've stated all your contentions and merits are kept open, and these are not. It's also clarified that the findings made herein will not come in the way of any other application being filed by the petitioner. No, that I've raised. Yes. Next. Yes. No, that's okay. Now, otherwise, no, I have given you enough observation. That would suffice. You can go ahead. Let us see when I'm drafting. No, that you can always file, but now I can't do it. Let me see when I'm. No. Next Baradilla. When I'm making the correction, if something comes, I will see. No done. No done. I'll see. Yes, next. Yes. Page.
Is it
53.
sorry, my lords.
Yes. Stay of execution procedure. You are the judgment debtor. Objector. Suit of the year. Suit of the year. Suit. Huh? 93 bar.
This move was decided on 1997. As far as it was passed.
Yes.
Other Kempama has purchased the 30 meters of the property. Because the subject matter shows. One.
30/2001. That is because of the property is
That is after the disposal of the suit.
after the disposal and after the execution was filed. In 2011, Bharat Kempama was aware of the
No,
application.
no, but her purchase itself is after the suit.
Both persons have jointly executed an affidavit of sale in favor of the second father. During the pendency of this suit, he has been the suit of the during the pendency of the suit, three of them has sold their portion. The fourth one did not sell the road, his portion. After his death, that is after the suit of the disposing of these developments has sold property in favor of the business of Empoma. Empoma has made an application in 2011. The execution is best known to them. The execution is pending 2000 to 2012. That execution is Empoma. Other children and grandchildren are fighting.
No, obstructor application was filed and rejected. No, but now that question is settled. Supreme Court has said all things must be considered in the same. No, you should have challenged the obstructor, dismissal of the obstructor. That
Any claim or objection has been adjudicated upon. Any claim or an objection is required.
no, no. Read 58(2).
All questions including relating to title, right title, or interest in property attached, anything between the parties, receiving from title. Given the application of the claim or objection, shall be recommended by the court, dealing with the claim or objection, not be a separate. That whether it should have been done.
No, but how can you file a separate suit when this?
Any claim or objection is different in the court. One. Just to explain. The party response to the ordinance may
58 is first of all only as regards to attachment. Here, that is different. 21 rule 97 is different. Now, what was the suit? Then how you can say attachment 58 will come into play.
Was passed. During the pendency of the soul, three of them have executed the remaining one item was not constituted in the transport. The country have executed the setting. One item is left. However, the suit is treated in respect of all the process.
Now let us have a look at the IA. Let us. Page 125. Order on IA number 3. That is the impugned order, is it?
Yes.
Now I've gone through the order. Now you have a copy of the order dismissing the objector application dated 3/2/2011. Seventy.
28.
This is in the same OS. Correct. Relating to the same OS. No, earlier OS. Which you are now seeking to set aside as. So in that, this is the order that is passed. Let us have a. Now let us, now you claim to your mother only. Now let us have a look at that order on IA. Now, in this order, the court comes to two findings. One, it says that the objector, that is Kempamma, had purchased the land after passing decree in OS 93 of 1990, dated 20/12/1997, and after filing of execution case on 13/12/2000. And then the court holds that it is that your right is after the decree is passed. But then now
The agreement was in the year 1991. Three of them have executed in favor of it. Therefore, the agreement has become influenced and there is no corresponding amendment either in the plan or in the execution. Changing the executed decree in respect of the entire 3 acres 18 gunas.
no, but you have. How can you challenge when you have purchased it after the decree and in the execution process? After the decree in the pendency of the execution process. Then now you can challenge that judgment.
Having regard to the fact that on board, 3 of them have executed. Therefore, the agreement has reflects the second respondent could not have enforced that agreement. Merely because I have purchased the property.
Now, what has happened to the suit?
The suit is pending.
So then you will have to seek relief in the suit. We can't stay the execution.
Therefore, during the pendency of the suit, I shall down the and
That will be subject to the outcome of OS 296. Now, if we were to say anything on merits, then your rights in the present suit will go. Suppose we were to say, well, so you withdraw it, with liberty, we will reserve liberty for you that the execution of sale deed, if any, in the execution proceeding will be subject to the outcome. No, correct. I will not say anything. I will only say whatever the outcome of the suit finally, it's up to him to take benefit of order that may come. So any let us application has been filed. The petitioner has sought for setting aside of the order dated 21/12/2019, passed on IA number 3 at annexure Q, and to allow IA number 3. The petitioner herein is the plaintiff in OS 296 of 2016 and has filed IA number 3 under section 151 of CPC. IA is at page 151 of CPC to stay the execution proceedings in execution 32 of 2000 pending before the civil judge at Magadi till disposal of the suit. The said application came to be dismissed by the impugned order which has been challenged in the present petition. The application is filed by Lingaraju, who is stated to be the legal representative of Kempamma. Full stop. Objections were filed to the said application. And it was specifically asserted that there was an earlier decree, OS 93 of 1990, filed for specific performance of the contract, which suit came to be decreed on 20/12/1997. It is submitted that execution 32 of 2000 was filed, seeking to execute the judgment and decree in OS 93 of 1990. It is further submitted that Kempamma, the mother of the present plaintiff, the mother of the first plaintiff, had filed an objector application in execution 32 of 2000, which came to be rejected. Accordingly, it was submitted that the sale deed having been executed on 13/12/2001 would not confer any rights in favor of said Kempamma, and a rejection of the application was sought. The trial court, by a after a detailed hearing, has rejected the application and has pointed out that the plaintiffs claim right through Kempamma, wife of Ramanna, who stated to have purchased the property as per the sale deed of 13/12/2001. It is further pointed out by the trial court regarding the dismissal of objector application filed by Kempamma on 31/3/2009 in execution 32 of 2000 with respect to the application filed under order 21 rule 101. Full stop. The trial court observes that the said order rejecting the application of Kempamma as an objector dated 3/2/2011 has attained finality and has not been challenged, and accordingly, claim of the plaintiff in the present proceeding amounts is barred by res judicata. As also, claim relating to declaration with respect to judgment and decree is barred by limitation. Full stop. Next, heard both sides. It is not in dispute that the plaintiffs claim right through Kempamma, and as pointed out by the trial court, the application filed under order 21 rule 101 of CPC by Kempamma in execution 32 of 2000 came to be rejected. It is clear that the purchase of property by Kempamma is on 13/12/2001, while OS 93 of 1990 was disposed of on 20th December 1997. And admittedly, as on the date of purchase by Kempamma, execution proceedings were pending. The application of the objector having been rejected, the present claim of persons claiming through Kempamma in the present suit cannot be decided without taking note of the order passed in execution 32 of 2000 on application filed under order 21 rule 101. Accordingly, we find no reason to interfere with the order of the trial court. Impugned order of the trial court. Needless to state, rights available under OS 296 of 2016 would follow the consequences of final order. Accordingly, petition is rejected. Yes.
My lord, serial number 54, my lords.
Yes.
My lords, I'm appearing for the respondent number 3, my lords. I sought instruction whether a such circular has been issued, my lords.
No, let us see what it is. I'll come, just wait. Let us see what the case is. Yes. Page? No, now what has happened to the trial court proceedings? No, what is that? So what is the case that is made out?
Basically, a suit for declaration and protection which came to be applied. In pursuance of the order and WP who came to be re-registered. Page number 16 itself, the imputed order itself states.
Page number
16.
It was re-registered.
Re-registered. The matter came to be remanded back to the tribunal. Consider a fresh application on the on that ground, the case came to be re-registered. While there was noted expressly in the first draft, plaintiff is present, verified his name and address, plaintiff has signed the order sheet. After that, contradictory to the same statement, clearly PhD by Vakalat for Harish without writing father's name, age and full address. Both requested PhD mentioned the father's name, age and full address of the third party Vakalat, for which PhD summons that is generally and question was to the law. As per the principles of the unit reported in the year 2006, and based on which the alleged the same ruling by the not completed. I would also predict the rulings that are there to see over 36. No such finding is reported in the said ruling regarding mainstream of the age of the party.
Why such a big issue on this? No, if you had written, what would have happened? I'm just asking you.
Very well.
No, I'm just now it says father's name, age, full address of the person in the wakalat to be mentioned. There ends the matter.
Very well.
And there ends the matter.
On the same, I think I had some verbal duels by what hence that just brought it before this.
After hearing the matter for some time, taking note of the objection raised while rejecting the wakalat, Third Council for the petitioner in all fairness submits a fresh wakalat with requisite particulars as required under law would be filed. Accordingly, the petitioner is permitted to withdraw the petition. If a fresh wakalat is filed as per requisite law and procedure, claim to be taken on record. Accordingly, petition is disposed of. All contentions, legal contentions are kept open. For this, why you have to stay and keep?
I just came on record. Yes.
Who appears for the other side? Other side? Good evening. What is the impugned order?
The court below has held that the application filed by one of the plaintiffs would be allowed of the another plaintiff, second plaintiff, may be allowed. When the first plaintiff died, without being any legal right, property belongs to her father. He has inherited the property from the federal.
No, I'll note the absence of the other side, and on the next date we'll proceed whether he comes up. No representation on behalf of the respondent when the matter is called out. Counsel for the petitioner submits that this is a matter of the year 2016 and proceedings have been stayed, and accordingly matter requires to be disposed of at the earliest. It is made clear that if the respondent does not appear on the next occasion, matter would be proceeded with in his absence. Relist the matter on 12th.
Petition is filed 1 year. Yes. Same room, I would again responded that by section to recall the same notice. Not that order, no, the right court. The same.
Now, what are the other IAs?
Now the that's
Lordships, in serial number 56, Your Lordships, I appear for respondent. I pray for a short accommodation in the matter, Your Lordships.
I appear for first respondent in second matter, my lords, in WP 5790 of 2020.
Now, what is the stay interim order? Any interim order is passed?
the requisition number of my lord, 2331 of 1691 of 2018. Already interim order in the was kindly see that application itself is not mentioned. Kindly see. So in the application,
in which interim 1 minute. Interim order is passed in which matter?
16691 of 2018.
16691.
Yes.
Prior to clubbing.
Prior to clubbing.
16691 order sheet is there. Petition separate order sheet. So where is the interim order?
The interim is also referred in the order.
No, it has lapsed. First, continue.
Now, my lord, what happened? I have filed application. Under order 21 rule 54 for attachment of the property. It is also rejected by the trial court. Against which my lord, I filed this. It is also pending. Therefore, my lord, 3 matters are clubbed together.
No, let the main proceedings go on. Meanwhile, I'm saying now some amount is owed to you, isn't it? Now, then why you are getting it only stayed? You can take further steps apart without prejudice to whatever contentions you have raised. Let your proceedings go on.
Now, my lord, what my main is petition number 5790. For a moment.
Put it. 3-4 ಅಂದ್ರೆ ಯಾರು ಮುಟ್ಟಲ್ಲ ಸುಮ್ಮನೆ ತಲೆನೋವು ಅಂತ ಮುಂದಕ್ಕೆ ಹೋಗಿ ಮುಂದೆ 59.
5790.
Now this is whose writ? Your writ.
Yes.
Correct.
Page 19 say page number annexure E. Page number 78. For the reason set out the annexed memo, the right is more complicated with some application filed by the degree holder against judgment data 1 and 3 upon property number 1. Action B, page number 61. Same part. I filed by the objector applicant under order of Federal section 151 of OPC and placed to pass an order recalling the order passed by the IA number 1, that is sale notice. This was rejected by the trial court. At the same set of fact, again the one more application is filed under section 151. That is allowed and sale notice will be allowed. Page number 94.
Now this order 21 rule 97 was on merits was rejected after consideration.
Question of kindly see last line
At page
number 76.
yes.
Last once he is a party to the earlier proceedings, he cannot take such
Page
page 76.
in view of internal page.
76.
Yes.
Once second that.
Yes.
Once he is a party to the earlier proceedings, he cannot take such consideration in this case. In view of the above discussion, I come to the objector is unable to make out any ground to allow this IA, hence answer point number 1. Therefore, my lord, the application IA number 5.
No on what ground the second IA was allowed?
Simply, my lord, because I see
IA number 11.
really
Passed by the same officer or different? Same officer. What is the reasoning given?
already dismissed and the objector filed the requisition for the dismissal of the application also for a regular appeal against the before the Honorable High Court of Karnataka. In order to find out this, therefore, my lord,
Now, on what ground this IA number 11 came to be allowed? Who appears for the respondent?
I appear for first respondent in this matter, my lords. My lord, this application, my lords, came to be allowed because this is an property belong to an institution, my lords. There is a judgment, my lords, may kindly, my lords, peruse of the trial court, my lords, annexure A, my lords, in page number 16, my lords. Institution was first defendant, my lords.
You are ready?
I am ready, my lords.
Yes. How much time you will take? If we can finish by within half an hour, I'll take. Otherwise, some other day. I don't want to break it. Date code. Next date you come. You take
Please.
up the main matter.
Please.
And then let us see.
I was first defendant in the suit, my lord. Suit against me got dismissed, my lords. In execution, I was not a party. Therefore, I appeared as an objector and filed an application. That application was rejected since you were already party in the trial court. Therefore, your application cannot be entertained. But, my lords, however, in execution, the property of institution, they want to sort the attachment and sale notice was issued. Therefore, after rejection of my objector application, I filed an RFA and also filed an application opposing, my lords, a sale notice is concerned because it's institutional property. Then, my lords, a president and secretary borrowed a loan under their individual capacity, not for the institution. That is what the observation in the judgment, and my lord, suit against me got dismissed.
What can we do? That's if some private individuals do it for the institution and you don't take steps in time, then there it goes.
Their recourse is, my lord, Schedule B properties available for attachment and proceed with the sale, my lord. This A property is the leasehold properties from, my lord's Davangere Development, Urban Development Authority. They want to sell this property, my lord, for recovering the money which is under leasehold property.
Let us
please, my lord,
relist the matters. On 12th, what is the steps not taken with respect to R3 and R6? LRs of? Now, before the trial court proceedings are stayed, is it? No, who is the deceased party in the execution? Let that steps be taken there independent of this. Okay, some acceptance of postal track sheet. R7 kodi. R7 kodi. R7 the postal track. 169919. In the item delivered in post track sheet disclosing that item is delivered in respect of R7. 16691. Yeah. In light of the postal tracking report, which disclosed that notice is served on R7 in WP 16691 of 2018. Notice is held sufficient. Office to show the name of R7 as served in the cause list. Necessary steps to be taken as regards the other respondents. Yes, relist the matter on date could 12th. 18th. Yes.
highly obliged.
Yes. Proceedings are stayed, is it? Yes, what is your objection? On some terms, we'll allow it. Recall of PW for further evidence. If you are in his place, put it. Now you just read that order, Lucas.
Page number 78.
It's a short order. You read from the beginning itself.
From 27. 15 and 16 under order 18 rules 17 of 15 under section 151 of 56 recall and reopen the stage of this case for further examination of CPT of 21. Further, she has filed IA number 18, 17, 18, 17 and order 7, 14 of CPC. So, bundle the delay information thereupon. Guardian of Plaintiff has sworn to an affidavit when she has stated that she has filed the suit for relief of partition and the stage is for cross-examination of PWS1. Further, the defendants have disputed relationship with plaintiff and for that reason, in order to prove the same, she has produced the document. Further, while instructing her advocate to cross-examine, it was found that the documents are totally section identified, etc. Other are not produced in this case for the reason that it was under the impression that documents are produced to the court, then it will not be returned in her favor and the same documents were required for the day-to-day and due to concentration. Earlier, she has not produced the said documents and for that reason, submits alone. On the other hand, defendants have filed common objection denying the government's as false and also stated that the plaintiff prosecution given instead of sufficient attitude. Further, the different documents produced along with the application are created for the purpose of filing suit and accordingly submits. The suit is fund for relief of partition and separate possession. It is conducted by the defendants by filing witness statement. And when case was posted for cross-examination of KW1, present applications are filed and suffice to say that.
Yes, sir. I have gone through this. Which paragraph? Which paragraph from this? Read.
But for reasons not to it, so I will not do this. Such argument are ready for the after conclusion of after learning and I think that there is more of having shown how to interact, right? Not able to I think already can be said that power matters
Yes, yes. In that case, the last lines of para 15 was reserved for judgment several times. In that context, the petitioner, who is the plaintiff before the trial court, has called in question the order dated 23/12/21, whereby IA number 15 to 17 filed under 15 and 17 filed under order 18 rule 17 and under and under 151 of CPC and order 7 rule 14 subclass 3 of CPC came to be dismissed. The applications IA 15 and only 2 IAs, but here they say 15 to 18. But only 2 IAs, 15 and 17 have been filed to recall and reopen the stage of the case for further examination in chief of PW1. IA 17 has been filed under order 7 rule 14(3) of CPC to condone the delay and permit production of the documents. By where are the IAs at page? As per IA number 15, filed under order 18 rule 17, read with section 151. Permission has been sought for to recall PW1 and lead further evidence, which is the next one. IA page, IA number 16 has been filed under section 151. Seeking reopen of the stage of the case. And IA number 17 has been filed under order 7 rule 14(3), seeking permission to condone the delay and permit the plaintiff from producing additional documents. The IA number 18 has been filed seeking to reopen. reopen the stage of the case. It was the case of the plaintiff that they wanted to produce Aadhaar card. Where do you get that? Okay. Seeking to produce voters list, election identity card, ration card, and Aadhaar card. The trial court has recorded that the reason for not having produced the same at an earlier point of time was that plaintiff was under the impression that the said documents he produced to the court would not be returned to her favor, and as the same documents were required for day-to-day use, the said documents were not produced at an earlier point of time. The trial court has considered the contentions of both sides and has proceeded to reject the applications by relying on the judgment of the apex court in 2013-14 SEC, page 1, in the case of Bagai Construction to its proprietor Lalit Bagai versus Gupta Building Material Store. The trial court has referred to the judgment of the apex court and has observed that where recall is sought in order to mark documents which are already in possession of party filing the application, same cannot be allowed. Heard both sides. Facts are not in dispute. The nature of documents sought to be produced, as narrated in the impugned order, being voters list, election identity card, ration card, and Aadhaar card, are public documents. Full stop. No doubt there has been some delay, but the explanation offered for such delay by the plaintiff is one that cannot be brushed aside. Full stop. The reliance on the judgment of the apex court without referring to the factual matrix in which such observations were made reflects a lapse on the part of the learned judge of the trial court. It must be noted that the judgment of the apex court has been passed in the context of the facts where in the words of the apex court within inverted comma para 15 ... It further shows that final arguments were heard on a number of times and the judgment was reserved, and only thereafter, in order to improve its case, plaintiff came forward with such an application to avoid the final judgment against it. Such course is not permissible even with the aid of section 151 CPC. The further observation at para 14 is also to the in light of the observations of the apex court being made where matter was reserved for judgment on many occasions. The observations have been made in such context. Nevertheless, without trying to curtail the tenor of the law laid down by the apex court, the present case is not a case which requires the rejection of a request of the plaintiff when the documents are to be produced are public documents and the case was still at the stage of cross-examination of DW1 when the application was filed. The lapse, if any, on the part of the petitioner could be compensated by payment of appropriate costs. Accordingly, impugned order set aside. The applications 15 to 18 are allowed. The case stands, the stage stands recalled and case is reopened and the documents are permitted to come on record pursuant to allowing of the applications. Cost of rupees 500 to be paid to the other side. Wherever interim orders are there, it would stand extended till the next date.
Now, after the order of the song, they are pushing this. It is nothing but great being part of the court, not only on the court, as I say. Now, this is the order. Oh, order number one aspect, pre-application. Because the statement and also because the three applications can be very rejected. We got three applications. Petition. Only two applications can be listed. I submitted before the Salah Roman while discussing the earlier petitions. Let us see later on. Condition of amendment allowed in the at the end, further earlier point of time. The 90 restaurant number one and by creating two documents in their favor, affect two different schools, representing single advocate, common advocate. So only of the restaurant number 1 year, he filed another city. Creating the documents. They considered this honorable court that they will not give any evidence. Any for
where is that? Which paragraph?
last but one. Paragraph for page number 7 and down. Page 7 down. This court must also observe that the contesting respondents not any industry. It is like the fact that or the petitioner is categorical that no such fresh evidence would be laid in particular consequence of proposal. And because I was that amendment of the system was offered by me, they said that we will not put anybody into this, we will not be reading further evidence.
Okay, we'll have it tomorrow. Let us. When is the? Huh? Let us see if that is. That we'll see. Let us tomorrow. If time permits, we'll take it.
A, my lord, based on understanding the respondent that they should not. Understanding.
Who appears? For Ganesh. I haven't finished with 68. Who appears for Ganesh? You tell him that you told me that there's an arrangement. So we say the same stands due to a paucity of time. Due to paucity of time, matter could not be taken up. The undertaking given on the previous date will be continued till the next date. This is the matter on next week on date. Now you have, good. By then you pay. You pay by then.
I was explaining what the kind of risk matter of God, lot of risk and
Interim order earlier granted is extended till the next day. Huh? Application for
Is making the submission on the basis of evidence. Then is right now, the matter is going on. It is pending for, it was pending for evidence. They did not appear, did not make any application.
Evidence for and document and written statement another so then hearing what
now what is your objection to the IA being it will result in some delay, but let it go. Let the handwriting expert give a finding on that. Let us see. No, let us see. I'll hear it. We'll list the matter on Monday. He's going to seek for adjournment. Yes. Yes.
Now the purchaser of the digital property, the constructed and the both the road.
We'll have it next week. Let us. Today it will have next week date. Yes. This is the matter in B group. We'll have it in B group. This is that yesterday's matter. This is the matter in Land Council for the petitioner submits matters not reaching, though it is of the year 2019. List the matter above B group in the same stage. Yes. ಸರ್ ಇದೆಲ್ಲ ನಿಮ್ದ ಇವ್ರದ?